that he has instructions, he has instructions not to press these read petitions. Also heard Sri N. Goswami, Learned State Council, and Sri S.K. Talukdar. Is he there? Just check up. And Sri S.K. Talukdar, Learned Standing Council, Cooperation Department. Para. Read petition accordingly read petitions stand dismissed on withdrawal. 56, 57, 58. Is there any interim order?
No, my lord.
Okay. Please.
Oblige, your lordship.
Maybe please, your lordship. Lordship, I beg to mention item number 11, lordship. Matter may be adjourned for the day only, lordship.
On a request, APDCL, have you informed APDCL?
I'm informed the revenue.
Don't make a mention, madam. We'll immediately impose cost upon you personally.
I have informed revenue, lordship.
What about APDCL? Without informing, don't make a mention. It's high time. We have been repeating this every day, daily basis. Yes, Mr. Das. Item 11. On a request made on behalf of the petitioner, matter is adjourned to be listed on when? How many days?
Friday, lordship.
On 28th. 23. Okay.
May it please, Lordship. Lordship, I beg to mention one WPC for withdrawal.
When?
Lordship, if possible by tomorrow.
Okay.
May please, your lordship. I beg to mention for IA Civil 85/2026.
IA for?
IA Civil legal for substituting legal heads.
You have filed it. Not listed as yet. When do you want?
18 March.
Thursday. We have it on 17th March.
Lordship.
Okay. 7. Oh, no. 18th. Oh, no. 18th is Wednesday. You're correct. 18 March. Okay. 18 March.
My pleasure, Lordship. I beg to mention for listing of one motion matter on Wednesday, Lordship. Highly.
Yes. Yes, madam.
I would like to mention item number 21, WPC 6995 of 2024.
Item number 21. Yes.
Not this case was Mr. A.K. Das was leading this case, Ajay Kumar Das, but he has been appointed as public prosecutor. That's why we are going to engage a new counsel. We request some time.
What is your name? Are you on record? Are you on record?
My name is not there.
No. You may not be reflected. But are you on record in the matter? Not. You're not on record.
No.
What is your name?
S. Hazarika. Hazarika.
Miss S. Hazarika, Learned Counsel, has informed that Sri A.K. Das, Learned Counsel for the petitioner, is not in a position to conduct this case, and therefore new counsel would be appointed. Full stop. She accordingly prays for an adjournment. Matter accordingly stands adjourned by 2 weeks to be listed on 30th of March to enable engagement, to enable the petitioner to engage new counsel.
May please, your Lordship. My Lord, I am praying for listing one eviction matter today itself, Lordship, because, Lordship, the circle officer went to the house of the petitioner on Thursday and gave some time without any issuing any formal notice, gave some time till today to remove his house on a allotted land, Lordship. Yesterday, the circle officer went to the house of the petitioner with full force and demolished his house and proposed to construct road by within 1 or 2 days, Lordship. School approach road. Lordship. They are trying to construct the school approach on the courtyard of the house of the petitioner, Lordship. Therefore, this is urgent, Lordship. May kindly take it.
Okay.
Lordship. Obliged.
Your Lordship, an urgent mentioning of withdrawal of a rate petition. On instruction of the client, the petitioner wants to withdraw the.
Okay, get it tomorrow. Yes.
May please, Lordship, I beg to mention a matter to list.
Fresh matter.
Yes,
Motion.
for motion.
When did you file?
Last week. Last week, my lord.
Last week. What is the matter about?
Urgency for debarring of a candidate from election commission.
Okay, Wednesday it will come. Wednesday. Okay.
Right.
Yes,
It please your lordship. Lordship, I beg to mention for listing of a matter in admission column, lordship.
matter of which year?
Lordship, I am engaged in motor vehicle trade dealership, lordship.
Matter of which year?
2024, lordship.
What is the urgency?
Lordship, due to stay order, lordship, I am suffering from financial loss, lordship.
You file an IA for vacating the stay order. You are a respondent in the writ petition.
Yes, lordship, I am for the.
Have you filed an IA for vacating the interim order?
Lordship, we have filed objection in the IA, lord.
Objection in the IA? You are the respondent or the petitioner?
I am respondent, lordship.
So what objection will you file in the IA? You will file your objection.
Lordship.
Huh?
Lordship, it
The
was-
IA has to be filed by whom? The other party or
By the
you?
petitioner, lordship.
Petitioner.
Yes, lordship. The petitioner has filed one stay order, application for stay.
Separately.
Yes, lordship.
Then there is a stay order.
Yes, lordship.
And you have filed your objection.
Objection, lordship.
When was the matter last listed?
In the year 2025, lordship, it was supposed to list after 2 weeks.
Okay, we'll have it on Wednesday.
Obliged, lordship.
Yes, what is this?
Lord, no, please, Lordship, my lord. Lord, I have filed an application for mutation by right of inheritance, my lord.
You have filed additional affidavit.
Yes, my lord.
What have you stated in the affidavit? What records have you
My lord, I have,
enclosed to show that you have a right?
yes, my lord. I have annexed, my lord, page 21 to 22, my lord, that is Jamabandi, land revenue receipt, trace map, my lord. Page 21, my lord, of my.
Where is your
original-
name? What is your name?
My lord, my name is, my lord,
Malik.
I am Malek Mahabullah, my lord. I am the legal heir of Soyed Mahabullah.
Where is your name in the Jamabandi?
My lord, page 21, my lord. Serial number 1, my lord. Soyed Mahabullah, my lord. Annexure 4, my lord.
Yes, what do you say?
I have to instruction because
I will issue notice at this stage. Your S. Islam,
Yes, yes, lord.
Heard 3 S. Islam Learned Counsel for the petitioner who at the outset has informed that an additional affidavit has been filed in connection with the order passed by this court on 18/2/2026. Full stop. By means of this petition, the petitioner has prayed for a direction for carrying out the mutation
Yes, my lord.
in respect of the land in question, full stop. In the additional affidavit, comma, in an additional affidavit filed by the petitioner dated 5/3/2026, comma, the petitioner has annexed copy of the Jamabandi. Para. Let notice be issued, returnable on yes, returnable when for it will go after the vacation on 22nd of April. What about the other petitioner, Mr. Islam?
My lord,
Their names are not there. Who are they?
my lord. Petitioner, my lord, page number, my lord.
There are 6 petitioners.
Yes, my lord. My lord, page number 13 of my writ petition, my lord. Page number 13 to 15, my lord.
Yes.
Matlab, sorry, my lord, page number 12, my lord. My lord, there are 5 legal heirs, my lord,
Of,
of late Soyed Mahabullah, my lord. My lord, serial number 3, my lord, page number 12, Soyed MD Mujahidullah died, my lord, leaving her wife and one daughter, my lord.
কি করলো?
I have annexed an okay, my lord.
Issue notice. Returnable on call to 22nd of April 3. Revenue, PR Mohanta, 1, and N Goswami 2, 3, and 4 extra copies. Okay.
Yeah.
Yeah.
Please, Your Lordship.
Yes, are you prepared this time?
This repetition is relating to civil bench too, actually, Your Lordship. Matter will be placed before the appropriate bench, Your Lordship. Bench 2 matter.
Why is it?
Education matter, Your Lordship.
It is not, has it got anything to do with education?
Education, my lord. Right. I have
It
gone
is-
through the records,
It has not got anything to do with education.
my lord.
You are asking your land to be given back.
Land is
We
a-
had asked you.
I have filed a representation before the education department. Right? As the education department acquired the land for the
It's a matter,
establishment of the
it's
school,
a
Your
matter
Lord.
of claim of a land.
My lord,
First, you have to answer that question.
my lord.
Where is there any contract that you can get some
My lord, there is a-
provincialization in
My lord,
respect
there
of
is a
donation?
contract. There is a contract, Your Lordship.
Can you enforce that contract? That you'll donate land and you'll get your
My lord,
service
he's a
provincialized?
layman. You say he don't know regarding that. Just
No, you-
for
you-
his service, Your Lordship. He for his service, he
Mr.
donated
Chaudhary,
the
do not
land,
make this kind of argument in a court that you do not know.
my lord.
If it's a contract, it has to be enforceable in law. Can you make a contract to steal something? And you said you do not know.
No, no, contract is a
What is a
consent,
contract?
contract and acceptance, Your Lord.
What is
My
a
lord,
contract? Are all agreements contract?
No, no, that is enforceable by law, Your Lordship.
For
An
donating
agreement-
land, you can get your
an
service provincialized.
Contract is that an agreement is enforceable by law, Your Lordship.
Can you enforce this?
My lord,
This particular agreement that you will get your service provincialized in lieu of donation of land, can you enforce this?
that is why regarding that, the petitioner is a layman, he don't know regarding that. That just he is for his service, Your Lordship. He donated the land to the authorities, Your Lordship. So, Your Lordship,
And
yes,
Mr. Chaudhary would not like your attitude. This matter was argued on 2 days. The matter, whether it's bench 2, bench 5 was deliberated. Now, on the 3rd day, when you were in a fix, you said it has to go to bench 2.
no, my lord.
You sort it out. We are here. We are not adverse to you. You
Why
convince us, get an order.
My lord,
Why are you trying to avoid the bench?
my lord.
2 days you had argued this matter. And today you are saying that it's a bench 2 matter. By what means of imagination it's a bench
No,
2?
my.
Is it going to do anything with your service? You are asking the land to be given back.
My lord, my simple
So,
prayer is.
so what is it this has got any connection with your service?
No,
In a school,
I don't
you
want,
want your land to be
Your
given back.
Lordship, I don't want service, Your Lordship. My simple prayer is to revert back my land, Your Lordship. So I have submitted a representation. Your Lordship maybe consider my representation.
Okay, heard Sri R.M. Chaudhary, learned counsel
Fine.
for the petitioner. Full stop. As per the facts projected, the petitioner was appointed in a grade 4 post in the BKME Madrasa School in the year 1994. And what is the date of the resolution?
Resolution, Your Lordship will find.
In the synopsis, what have you written? 22nd of December 2003.
My lord,
And you were appointed in 1994.
my lord.
How is it possible?
Representation, Your Lordship.
No, resolution. Come to the third
Resolution, your lordship.
sentence of your synopsis.
My lord.
By resolution of the managing committee. Full stop.
And then agreement between the petitioner and the managing committee, if the post of provincialization, the post
Ah.
of the.
It
four
is
numbers of
contended
is,
that the petitioner had donated land with an understanding by the agreement dated 2/12/1994 that if his services are not provincialized, the land would revert back to him. Full stop. It is submitted that since his services have not been provincialized, the land should be reverted back, and therefore this present petition, full stop, whether an agreement of this nature is enforceable would itself be an issue which would require consideration, full stop. But be that as it may, that notice be issued returnable on today, returnable on 22nd of April 2026. Yes, we'll take number 1, Khatonier, NJ Khatonier for 1 and 2, 1, 2 and 3 also, I believe. 1 and 2. And Miss B. Bora, standing counsel BTC for 3,
4, 5 and 6.
3, 4, 5 and 6. Revenue, PR Mohanta for 7. 8 also, I think you can take. Circle officer?
No, my lord.
8 is by SS Roy. You serve extra copies. Maintainability of this writ petition is however kept open.
Master.
Published to reflect J. Assam.
Item 3. Please, your lord.
Yes.
My matter relates to my lord without issuing so cause notice, my lord. Order has been passed under section 74A. Matter is squarely covered, my lord. I have made correction. My learned friend.
Just check up, okay? A. Goyal and H. Borwa. Finance taxation, dispose of court.
Deeply obliged.
Please get the corrected copy and hand it over to our court master.
4 and 5.
Four and 5.
Cancellation of GST registration. Lordship. I pray for similar order.
CGST.
This is CGST Lordship, and item number 4 is 5 is Lordship State Finance Department.
Where is the finance department? Yes, Mr. Barua. Covered.
Cancellation.
Cancellation covered matter, my lord.
Cover and the other one, CGST.
Lordship, that is also covered.
Who's there? Madam, you're for CGST.
Lordship, she's
On behalf of Union of India. Union of India perhaps will not have much of a role.
she's appearing for
CGST. On behalf of
Dr. B.N. Gogoi.
Dr. Gogoi. Have you looked into the order?
Your lordship, actually my senior is appearing in another court, therefore let the matter.
Let him come for the other
for
matter.
item.
Or Mr. Barua's matter
Five, my
will.
lord.
Huh?
Item number 5, my lord.
5 we can dispose of.
Yes,
My
yes.
lord, covered matter.
Okay, 5 make a corrected copy, 5 to dispose of.
And 4 we will wait.
N. Havelia and H. Barua. And 5 CG, central government is a party, no?
No.
Okay, and 4 after a while, huh? 4, madam, come after a while. Let the, yes, Mr. Kyle? Oh, you're not there. Oh, Dr. Gogoi is there, okay. Let Dr. Gogoi. Oh, Dr. Gogoi is here. Yes, Dr. Gogoi.
I apologize. I wasn't.
No, is it covered?
Yes, it's a covered job with my lordship own judgment.
Okay, then.
Nothing else.
Okay, and madam, your name? R. Datta, on behalf of? You are a CGC. You are a CGC. R. Datta CGC and Dr. B.N. Gogoi are NHW. Okay,
Much obliged.
I'm deeply obliged, lordship.
please make the correction, oversee the, verify the correction and hand it over to the court master.
Lordship. Item 6.
May it please your lordship. Lordship, in this matter, we have challenged a so cause notice. For
You are supposed to
cancellation
have
of
the
this
instructions.
Awaited, my lord.
Lordship,
Awaited.
My lord.
Lordship, subsequently, respondent authority has passed an order for dropping the proceeding. As it is, they have,
My lord, may dispose it of, my lord.
Well, dispose it of them.
Yes,
Do you have a
Yes,
copy?
yes, Lordship.
Your B. Sharma, heard Miss B. Sharma, learned counsel for the petitioner who had filed this writ petition against an order of suspension of GST registration, which was provided under the Assam Goods and Services Tax Act 2017, as well as the Central Goods and Services Tax Act 2017. Full stop. The primary contention was that the proceeding was initiated by issuance of show cause notice without supplying any specific grounds. Full stop. Para. When this matter had come up for consideration on 9/3/2026, the Learned Standing Council, Finance Taxation Department was granted time to obtain instructions. Full stop. Ms. Sharma, the learned counsel for the petitioner, has however informed this court that recently on 11/3/2026, a communication has been made to her whereby the proceeding has been dropped.
As it is subdued
And
under this law.
the suspension of the registration has been revoked from 11/3/2026. Full stop. In view of the aforesaid development, this court is of the opinion that there is no surviving cause of action which requires any adjudication. Para. Writ petition accordingly stands closed. A copy of the communication dated 11/3/2026 is made part of the records.
Lordship, may grant liberty if the cause of action
That is already
is
there.
again.
Okay. It is needless to state that in case there is any future course of action, there will be no bar on the part of the petitioner to approach the appropriate forum of law.
Deeply obliged. Lordship.
May I please?
Yes.
My lord, the matter relates to, my lord, election of the Anchalik Panchayat President and Vice President, my lord. My lord, what has happened? It is a election for the, my lord, Dolgaon Sialmari Anchalik Panchayat, my lord. As per section 37, my lord, the first meeting was held on 18/7/2025, my lord. And in that meeting.
Just a minute, Mr.
My
President.
lord,
First meeting is
18/7/2025, my lord.
First meeting.
My lord, and in that meeting, the election was, my lord, officially held. And in that meeting, my lord,
Who are you?
my lord, I am the, my lord, one of the member. My lord,
Elected member
elected member, my lord,
of Dolgaon.
Dolgaon Sialmari Anchalik Panchayat, my lord.
Okay.
Now, my lord, in that meeting, along with me, another 7 members, my lord, voted in my favor, my lord. That comes to, my lord, 8 numbers in my favor.
You contested for the post of president.
No, my lord, because it is Anchalik Panchayat, my lord. Amongst the member, one person is required to be, my lord, elected as a president, my lord.
That is it. You contested for the post of president.
My lord.
And the meeting was held on 18/7/2025.
My lord.
How many contestants were there?
My lord, altogether two contestants were there, my lord.
Respond number?
9, my lord.
And R9 contested for president.
My lord.
Yes.
And my lord, in that meeting, what has happened, my lord?
You got how many votes?
Total vote casted in my favor was 8, including me, my lord. 7 plus 1.
Okay.
And again,
total numbers?
Total was 15. Quorum strength was 15, my lord.
No, total number of elected members is 15.
My lord. My lord.
Yes.
Now, in that, my lord, vote was casted in favor of me was 8, my lord, and against the private respondent number 9, it was 7.
R9 7.
R9 7, my lord. It was a ballot voting had been done, my lord, when it's, no, 7.
7 and 8 makes 15.
15, my lord.
Correct?
So therefore, my lord, when the, my lord, election was over, suddenly this private respondent had been declared to be the elected as a president, my lord, by the
On what basis?
basing, my lord, that is the issue. Then, my lord, we raise a complaint, representation has been made before the co-district commissioner as well as the district commissioner, my lord. But those representations are still, my lord, though acknowledged, but still those are, my lord, has not been taken care of and it is pending, my lord. So therefore, now we are before my lord.
Yes, any instruction, Mr. Doctor?
That was conducted by the district commissioner.
No, if he has got more votes than the
My-
private respondents, 8 and 7, if at best it could have been a tie. If his vote somehow 7-7, then also you go for a toss. Have you enclosed the first meeting?
No, my lord, we have in the representations, my lord, we have stated in details.
Why haven't you? That would be crucial.
Which one, my lord?
The first meeting resolution,
My lord, my lord.
where is that?
No, my lord, that had not been provided to us, my lord. That,
Where have you stated?
my lord,
This is the vital document
No, my
from
lord,
where we'd be able to know what has happened actually.
my lord, my lord, my lord.
Where have
can-
you stated that it has
My
not
lord,
been
yes.
provided to you? Just a minute, just a minute. So where did you come to know that he has been elected?
My lord, my lord. My lord, can. Paragraph 8, my lord. My lord, can peruse paragraph 9, my lord.
No, not 9. It's 6. You have stated in 6.
6.
That is what is important.
My lord,
6 last line.
my lord, my lord.
Okay. Yes, Mr. Dutta?
My lord, if lordship may kindly have 127 section.
Yes. Election Tribunal.
Yes, the Constitution of Punjab Election Tribunal. This, my lord, only excludes, my lord, section 10 of this act. Section 10 is the, my lord, election of president in a Gaon Panchayat level. For Anchalik Panchayat and district level, my lord, 127 will applicable. Because district commission doesn't have power, my lord, to settle the election of the Anchalik Panchayat and the Zilla Parishad, as per 120.
Mr. Bhuya,
My
when
lord,
submission?
My lord, if it is the prescription of the law, my lord,
Yes.
then my lord, can it be taken up on next Friday, my lord? I
We can have it today itself. You can take an instruction, you can withdraw. We'll give you liberty to file, but that is within a specific time.
60 days, my lord.
60
Now
days
it is
now.
almost a year.
Almost a year.
My lord.
Almost a year. We
Of the election of president.
That is the
That day 60 days.
60 days.
yes, first
18
way from 18-7.
18/7, 60 days.
18-7, long past.
They have waited.
No, they were under. We can make some observation
My lord.
that you file an application for condemnation that would be considered. You can also cite that representation, but that is not that not be proper.
My lord. If
Should we pass that order?
Lord,
We pass that order. 127 is there.
then my lord, can it be taken up at 2
o'clock,
2 o'clock? Silence. My lord, this,
Just a minute.
my lord.
Item number,
May I please, your lordship?
please.
My lord, this is a matter wherein, my lord, we are facing an eviction notice, my lord. What has happened, my lord, the government, as per their policy, my lord, allotted certain portion of land, my lord, in favor of the forefathers of the petitioners or the legal. Now we are some of the, in the name of some of the petitioners as well as, my lord, legal heirs are also before my lord now. My lord may be pleased to find is that page 24 annexure 2 is some of the, my lord, certificates by which this allotment had been provided, my lord. My lord, may kindly turn to
Page?
page 24, my lord. Annexure 2, my lord. This is a certificate, my lord, issued to one of the petitioner. The below mentioned scheduled land obtained through the land acquisition law has been provided to you under the below mentioned condition of your use. So, my lord, this is the translated part, and the vernacular part is, my lord, is that annexure 2 is a one kind of certificate maintained by the Land and Revenue Department, my lord. So, by virtue of
What is
this,
the date of this
my
certificate?
lord, the date of this certificate is, my lord, may be pleased to find. From 1970s, my lord, we have got this allotment, my lord. We have made a specific statement.
No, where is the date?
Date is, my lord, not very, the vernacular also not very legible, my
No,
lord.
there is no date in the vernacular also.
My lord, my lord.
Tariq is blank.
Yes, my lord. That is
Left side.
yes, my lord. Tariq is blank, correct, my lord. No, my lord, if my lord want to peruse the original.
No, that is okay. Then what has happened? No.
My lord, now, my lord, by virtue of these allotment orders and certificates, my lord, we are continuing the possession and enjoying cultivating the land also.
Since how many years?
Since from 1970s, my lord. Since 1970s. And my lord, suddenly, what has happened, my lord, a notice had been circulated, my lord. My lord may be pleased to find those notices I have annexed, my lord. Page number 94, my lord.
94.
94, annexure 9 series, my lord.
Date?
Date is, my lord,
31/12.
31/12/2025, my lord. Vernacular at the top, my lord. Yes, in the translated also, my lord, we have 31/12/2025. Regarding, you are hereby informed that you are allegedly encroaching on the government land in tulip number 3 so-and-so village of so-and-so building houses. Therefore, you are requested to submit the relevant documents in your possession regarding the land. My lord, pursuant to this notice, we have already submitted, my lord. We have. Now, my lord, what has happened? After the submission, till date, my lord, no decision has yet been forthcoming from the authority, my lord. And on the other hand, people are, my lord, approaching that we should vacate, my lord. So, my lord, once we have submitted, my lord, let them take a decision, my lord, whether we can reside there.
Why are you preempting them from, or whether why are you forcing them to take a decision? They have not taken a decision which is adverse to
No,
you.
my lord, what is, yes, my lord, that is
Now,
correct.
without a notice, without an order, how can you be evicted?
No, my lord, the men are coming. My lord, the revenue officials, the forest.
So we can get instruction, but we cannot pass a blanket interim order.
No.
There may be some orders of eviction we do not know.
Yes, my lord.
But if there is no order of eviction,
Try the lots.
No, my lord, my friend can, a senior friend can take instruction, my lord, no problem.
Wednesday.
My lord.
Part 3A Bhia, learned counsel for the petitioners. First up, the petitioners who are 67 in numbers are aggrieved by threatened eviction from their respective plots of land. It is contended that lands were allotted to their forefathers and to some of the petitioners also, and they are in peaceful possession for a long time. Full stop. However, on 31/12/2025, notice was issued by the circle officer directing them to submit the relevant documents, which, according to the petitioner, they have done. Full stop. In spite of such submission, no final orders have been passed, and on the other hand, the personnel are visiting the area, which has raised raised apprehension on the mind of the petitioner of their eviction in a manner not prescribed by law. Full stop. That
Whether they have filed a show cause, that is not elect option. What reply they have.
Yes, if we have filed or not. No, we have stated.
now we'll do one thing. You have not even given, you're correct. Sri N. Goswami, Learned State Council has submitted that the replies alleged to have been filed have not been enclosed to the petition. That notice be issued returnable on we'll give a short notice, okay?
Mal.
Returnable on 1st of April 2026. Three,
And for 1, 4, 1, 3, 4, and 5.
three, Goswami, huh? And Goswami State Council, 1, 3, 4, and 5. And revenue, Madam P.R. Mohanto, extra copies. Para, 3. Yeah. The learned
Mal.
council prays for an interim order, para. The application, the present petition has been filed mainly on apprehension, as there is no notice per se requiring eviction, and the notices which were issued way back on 31/12/2025 was only pertaining to the aspect of submission of relevant documents. Full stop. Under those circumstances, this court is not inclined to pass any blanket order of stay. Full stop. However, it is provided that no action for eviction of the petitioners be taken without following the due process of law.
Mal. Deeply obliged. Deeply.
You come up with instructions, what has happened?
Lordship, Lordship, in this case, there is an error, Lordship, with the index page. Let me change this, Lord. Let it
Index.
come day after tomorrow, Lordship.
Okay.
Copy paste mistake. Lordship.
Okay. On a request made by Sri B. Chakraborty, matter is adjourned to be listed on Wednesday.
I may be allowed to change that page, Lordship, index page.
No, nowadays, my lord, it's difficult.
Index is not pleadings, perhaps index you can. No. Sri B. Chakraborty Learned Counsel for the petitioner. Petitioners or petitioner has submitted that due to inadvertence, some error crept in the index page, and therefore he prays for a liberty to correct the same. Full stop, para. Matter is accordingly adjourned to be listed on Wednesday, by which time the petitioner is directed to submit corrected index.
Hello.
One case we had recorded your name, Mr. Talukdar. It was withdrawn. 3 cases rather in the morning. We asked somebody whether you were there in the court, but tentatively you have given your name. Which cases? 56, 58, 57, 58. Yes, what are these?
My lord, it was a very limited prayer. In fact, my lord, what has happened? There is a cancellation of the registration, my lord, GST. Now,
covered or what?
There are judgments of your lordships, my lord.
Twenty-four. The consideration of the representation will only be, will it serve any purpose? Because the orders passed by this court is not for restoration, it's for consideration. Now, if it has already been considered and decided against you, and you have a provision for preferring another appeal, so can a writ court do anything?
My lord, in fact, everything, my lord, has been cleared along with interest. Now, there is a judgment of your lordships.
Now, those are where appeals were not filed, representations were given. Here, your appeal has been filed, rejected, or maybe on the grounds of limitation. And the statute provides for a second appeal. Now, remanding back when a decision has already been taken, you think over what is that appeal 122? Pre-deposit is required.
In this case, it is not possible. If there is no.
Because it's only the aspect of, it's not regarding any quantity involved. It is only regarding the cancellation aspect.
No, it's rejected only on ground that beyond limitation I have filed, nothing else. Merit, not merit. And I was,
We can send it back to the appellate authority also.
yes, my lord.
First appellate authority.
Yes.
Even though a second appeal lies under these facts and circumstances, and the aspect that he has already cleared the.
My lord.
Okay.
Everything has been paid along with interest, my lord.
So, do you have a similar order?
Yes, my lord.
খালি এটা বস্তু লিখে দিবা।
Definitely is not correct because after restoration process, the department will calculate. They will be allowed to file returns for given periods.
We'll say something on that. Roman লিখে দিবা। Free Kyle, mother, then it's Leonard Senior Standing Council CGST has, however, submitted that against the order of cancellation, an appeal was preferred, which was, however, dismissed. Which was also dismissed, however, on the grounds of limitation. And the statute provides for a further appeal under section 122. 112 of the
CGS
17 Act.
2017. Yes, 2017.
CGST Act 2017. The aforesaid submission is also endorsed by Sri H. Barua, Leonard Standing Council, Finance Taxation Department. This court has, however, taken into consideration that since the rejection is not on merits, the matter, and in spite of the fact that there is a provision for preferring a further appeal, the matter be remanded back to the first appellate authority to take a decision on merits, wherein the aspect of clearing the what? Of respect of filing the previous returns will also be taken into consideration. Full stop. The petitioner may also be given a further scope to file any returns which are still pending at the time, till the time of such adjudication.
My lord, I will only say at page 21 and 22, I have, my lord, substantiated, everything is clear. Page 21, 22.
No, that you have already said.
Yes, correct.
But Mr. Kyle says that till the time of
adjudication. My lord. Whatever is there, I'll pay.
Give an order. What is this?
My lord, para 5 and 10, my lord, this is a lordship's order. There, my lord, the delay was condoned, my lord. 217 days delay, my lord. Here also on delay, my lord, it has been rejected. Send back, my lord, it was sent back. And para 10, 5 and 10. It was also rejected under 29(2)(c), my lord. Same case, my lord.
Okay, you can make the corrections here.
Yes.
Please make the corrections. Get it verified by Mr. Kyle and Mr. Barua and give it to our court master. Oblige.
I'm obliged.
Yes, next. Sir Ganguly.
May please read. But this case, petitioner is a senior citizen, my lord. He has approached this court because of an violation of the approved plan by the private respondent, my lord. If your lordship sees, my lord, page 24 onwards, this is the construction, my lord, on the
R7 is making some illegal construction.
my lord,
and no action has been taken by the Tezpur
no
Municipal
action
Board.
has been taken
That is
without
your-
maintaining, and even, my lord, the front public road part also he has encroached. That is the most
Who's
shocking.
the respondent number 7?
He's a private respondent. In fact, he's my neighbor only, my lord. And now the situation is that outside this hotel, this tea shop and hotel that he has put up, now virtually people are sitting on the road, man, on the public road, which is, and there is a hostel, there is a hospital also nearby. Absolute, my lord.
Yes, we'll issue notice at this stage. Part 3A Ganguly, learned counsel for the petitioner who is aggrieved by inaction on the part of the Tezpur Municipal Board with regard to her complaint of encroachment of public space by the respondent number 7. Full stop. It is submitted that the respondent 7 has made illegal constructions in violation of the approved plan, causing immense hardships to the petitioner and as well as the general public. Para, let notice be issued, returnable on 6th of April 2020. It's not 6th, on 20th of April 2003. SS Roy State Council for 1,
Lordship 2, 3, 4, and 6.
2, 3, for Director of Municipal Administration, you can take perhaps.
Lordship.
1, 2, 3, 4,
Lordship, yes. 1,
and 6.
3, 4, and 6.
What about 5?
5, I will take justice also.
5 and 7.
7 may be difficult because of
Then
the
5 and 6, 5 and 7, that takes speed post to TD.
lodge. No, on 5, my lord, I seek liberty to take justice also. In addition, my lord. In addition to the
let first establish taken by speed post. Let us see if they do not, if there is delay in their.
My lord, it's a matter of record, my lord. In various matters, they delay and don't even file affidavits. The board is absolutely.
Let us see 5 and 7 by speed post to DD.
Let's
Extra
only
copies.
one prayer, my lord. Let it be subject to the outcome of the petition. Otherwise,
it is three. Ganguly, the learned counsel, praised for an interim order. Full stop para. While at this stage, interim order, while at this stage, it may not be possible to pass any blanket interim order, it is provided that any constructions made in the meantime shall be subject to the outcome of these petitions and further orders that may be passed.
Lodge. Yep.
You serve extra copies and take steps immediately.
Lodge.
Returnable date for issuance 2028, please study. Please April. Yes, Mr. Ahmed.
Milord, in this case, Milord, in 1955, Milord, Bazar was established, Milord. Thereafter, Milord, as per
1955?
Yes, Sampupara Bazar was established.
Bazaar was established.
Yes. Thereafter, Milord, in 1995, Milord, Deputy Commissioner of Kamrup, Milord, sent proposal for allotment, Milord, and ultimately, Milord, in the year 1999, 35 bighas land allotted to the Bazar, Milord, and thereafter, Milord, in 2000, Milord.
Where is it Bazaar? Where is this Bazaar?
Yes,
Where?
Sampupara Bazar, Milord.
Where?
Sampupara Bazar.
Where is it?
Soigao, under Soigao police station.
Okay.
And thereafter, Milord, in the Sita copy also corrected, Milord. Thereafter, circle officer also issued certificate about the activities of the Bazar committee. In the meantime, Milord, Bosundara 3.0, Milord, with intention to provide the Patta, Milord. The petitioners applied for Patta, and accordingly they submitted all the documents before the competent authority, but did not take any steps. The petitioner submitted representation as well as appeal filed before the Deputy Commission. That was pending, Milord. Appeal is pending.
Appeal filed when?
9/12/2025.
9/12/25.
Yes. Representation, first representation, Milord, 14/5/25. Next representation, 29/11/2025. Thereafter, Milord, 9/12/2025, appeal was filed.
Yes, what do you say when issue notice at this stage? Heard Sri A.M. Ahmed, learned counsel for the petitioners. First up, it is the case of the petitioners that in the year 1955, the petitioner number 1 Bazaar was established, and subsequently in the year 1999, 35 bighas of land was allotted to the Bazaar. Full stop. Subsequently, the formalities were done, and under the Vasundhara 3.0, the petition number 1 had applied for issuance of patta,
Yes.
which has not been acted upon. The petitioners have filed representations dated 14/5/2025 and 28/11/2025 followed 29/11/2025 followed by an appeal dated 9/12/2025 which have not been acted upon. Tara? Let notice be issued. Returnable on 20th of April 2026. Revenue Department, PR Mohanto 1,
2 and 3 MA.
2 and 3. 2 and 3, 2 and 3.
MA present.
State Council, extra copies.
Obvious.
Yes, Mr. Stek?
May it please the lordship.
Yes, please.
My lord, petitioners before your lordships are allotees, my lord. But in spite of their allotment, my lord, on 11/11.
You were allotted lands.
Allotted
You were allotted lands.
land.
Thereafter,
Then what happened, my lord? Government issued a notification 11/11/2022,
yes.
whereby for settlement of land under Assam land policy, my lord, 2019, that the interested person can apply. We applied, my lord. In spite, after that applications, my lord, acknowledgement was given to us. But now what happened, my lord, during pendency of that application and in spite of, as we are allottees, now they want to evict us without issuing notice. That is at para 8, my lord. Para 8, phase 8.
Without notice.
Yes, my lord.
How is it possible?
So we are landless persons, my lord. Why they will evict us? They should issue patta to now. Because allotment is given to landless persons after due inquiry, my lord. Now, my lord, they cannot evict us without giving notice and without issuing patta. How
No, there cannot be any vested right for issuance of patta, but there would be a right for consideration.
My lord.
Fair consideration.
As per
As per the
Salahuddin, my lord,
policy of
bona fide
2019.
claim is there.
Yes.
Bona fide claim is there.
No, bona fide claim would be on the other aspect of eviction.
My lord.
We are not on the aspect of eviction. We are on the firstly on the aspect of allotment.
My lord.
Okay. Without considering, perhaps you were saying that you cannot be evicted.
Yes,
And
ma'am.
number two, we do not find any eviction notice.
No, my lord.
You are only apprehending.
Yes, my lord.
Yes, Mr. Roy.
The instruction.
Okay, issue a short notice.
Lordship.
Don't take action without following the due process.
Lordship.
Okay. And also take instruction. What is the stage of the consideration of the application for allotment?
My lord, allotment is already issued, my lord. I have annexed the certificates.
Regarding your settlement under the
Settlement, my lord.
policy of 2019.
2019.
Okay. Heard 3M is a learned counsel for the petitioners. Full stop. It is contended that the petitioners were allotted certain land as they were landless, as they were landless persons. And on 11/11/2022, a notification was issued opening the process of settlement under the land policy of 2019, under which, the petitioners had filed application. Full stop. However, without such consideration, the petitioners are having apprehension of their eviction as certain personnel from Revenue Department had visited their locality and informed about such eviction. Full stop. Para. Let notice be issued, returnable on when, Mr. Can we have this on 6th of April? Or on the reopening?
Reopening.
On 20th of April? 3, Madam Mahanta.
2, 3, 4.
Madam Mahanta for 1. And Roy for 2, 3, 4, and 5 extra copies. Full stop. 3, 6. The learned counsel.
I
for the
have been to
petitioner
plan, my lord.
prays for an interim order. What's the para? In absence of any documents to show that an eviction process is on, comma, this court is not in a position to pass any blanket interim order. However, it is provided that no eviction can be taken of the petitioners without following the due process of law. More particularly, this process of law, including the principles laid down by the Honorable Division Bench in the case of Salakuddin versus huh? You get instructions, what is their fate of the applications filed under 2019 policy? Okay.
Obligation. My lord, in this case, my lord, we are agreed by an order that is at page, my lord, 69 to 70, my lord. My lord, what is
69 to 70.
69 to 70, my lord.
What is it?
My lord, actually, the fact of the case is.
Who are you? Ochom Onuhusita
Ah.
Jati Jubo Chatra Honta.
Yes, my lord.
What
My
is
lord, the
your
petitioner is a, my lord, a scheduled caste organization, my lord.
okay?
My lord, we have come to know that the private respondent number 11, my lord, by unfair means has obtained a scheduled caste certificate, my lord.
Okay.
So we made an inquiry and we went to their school, my lord, where he used to study, my lord. There we come to find out that from the admission register, my lord, that is at Annexure 5, my lord, that initially when the private respondent took admission in the school, he was shown to be an OBC, my lord. OBC. That is at page number 35 and 36, my lord. And the school's headmaster also issued a certificate to us, that is Annexure 4, my lord. That's why he's saying that he was an OBC when he took admission. Later, my lord, he made one certificate that is an SC certificate. So our case is that when he was an OBC earlier, how can he become an SC later on, my lord?
Okay.
And now, my lord, so we made several complaints, my lord. And on the basis of our complaint, my lord, one inquiry was done. But in the inquiry report, it is seen that our main contention that, my lord, that earlier he was an OBC and later he became an SC. That was not considered, my lord. So that is our ground of challenge, my lord, mainly.
What about Madhuri Patil, Kumari Madhuri Patil?
Madhuri Patil, my lord. I have no idea.
You are doing a case of cancellation of a caste certificate. You do not know what is Madhuri Patil.
But here, my lord, only the inquiry report.
You have to know. We expect you to know what is Madhuri Patil, and come back to the court on Wednesday.
Yes, ma'am.
Okay. You are the complainant in the case.
Everywhere I am the complainant. Our organization is a
We
complainant.
can issue notice, but you have to know what is Madhuri Patil.
Yes, ma'am.
Strange, you do not know what is Madhuri Patil.
Yes, ma'am.
Yes, on Wednesday. On a prayer made by Sri I. Chaudhary, learned counsel for the petitioner. Matter is adjourned to be taken on 18.
Great.
Yes.
Here, matter is to my lord, non-issuance of proposed notice. Only DRC 01 was issued, my lord. Is otherwise covered by lord.
Friday on
My lord.
them to notice on Friday.
Is a covered
On the notice.
A day after tomorrow. Friday, very difficult. Then Monday. Okay. Monday, we'll have it on Monday.
My lord.
Heard Sri R.S. Mr. Learned Counsel for the petitioner. What's up? Petitioner who submits that the issue involved has been dealt with by this court in earlier cases and would be covered by such decisions. Para Sri B. Gogoi, Learned Standing Counsel, Finance and Taxation Department, praised for some time to obtain instructions in this regard. Para list on. We'll have it on 23rd.
23rd.
Okay.
Much obliged, lordship.
Item 17.
It's enough. Yes,
Yes, my lord. Two.
we take this for disposal.
Yes, my lord. Yeah, two KBP, Kisan Vikas Patra was taken by the petitioner
Two
institution.
cannot be was, two cannot be was, has to be
Where, madam? Yes, madam.
Two KVPs.
Yes, well, for 10,000 each, my lord. And it
What
was,
you had purchased?
yes, my lord. The petitioner institution has purchased
Okay.
two Kisan Patra.
Oh, you are not given interest. That is your case. If it's purchased by.
Yes,
What is your policy, madam?
So as per the policy, since 1/4/1995 lordship, no institution is entitled to get the interest on Kisan Vikas Fund lordship.
This has to be challenged.
Yes, the thing is that, my lord, when the petitioner has gone to them, they should have returned, my lord, the amount at that time.
When
2007.
When did you open?
In
2007.
2002. It was matured on 2007.
2000.
They have approached, my lord. They should have, my lord, informed them, no, you are not entitled to interest. Rather, in the affidavit, they have said, my lord.
So what do you get after 5 years?
Sir?
What amount do you get after 5 years?
Well, for 10,000, you will double of the amount to 20,000.
That is it.
So, two is
So what are you
40,000.
claiming? Extra interest?
No, 40,000. That interest, that 10,000 along with the interest is double of the amount. There is 20,000 plus 20, two Kisan Patra. So that has been withheld, man.
Now what have you got after on the maturity?
No, maturity, they have stated in their affidavit itself also, my lord.
What is the amount you have received on maturity?
No extra single amount.
You got only 10,000 plus?
No, even that principal amount also did not receive.
Madam?
It will be released lordship. They have not imposed because they is seeking interest lordship, which is they are not entitled.
So you get a Kisan Vikas Patra by an organization, have it for 5 years, you get nothing. Let us see your notification. Are you correctly interpreting the notification? Let us see. Have you filed any affidavit? Page?
Page
It starts at 26. Where is the notification?
33.
32, Annexure A, the relevant portion is at page 33.
Which one, madam? Notification dated 1/4/1995. 1/4/1995. Which one? 8 March.
March 1995.
No, which notification?
33.
So there are several, two, three notifications. Which one? The left or the right? 8 March.
8 March.
So you said 1/4, it is 8 March. Please read in excess of.
Section 12 of the Government Savings Certificate Act 1959, 146 of 1959, and central government. The central government hereby makes the following rule. Further to amend the Kisan Vikas Patra Rules 1988, namely, these rules may be called the Kisan Vikas Patra Amendment Rules 1995. They shall come into force. In the Kisan Vikas Patra Rules 1988, in Rule 6, under the heading Types of Certificate and Issue thereof, for clause A of the following substituted, namely, a single holder type certificate may be issued to an adult for himself or on behalf of minor or to a minor, a trust.
So where is the interest part?
Post Office Savings Banks account manual also at page 43, Lordship, it is in section 143, subsection 3, Roman 2,
Page?
page 43.
Yes, please.
153, subsection 3, Roman 2. Issue of KVP in the name of institution, banking companies, local bodies was discontinued with effect from 1/4/1995.
What is this, madam?
Yes, it is.
This salient features is part of what?
It is a Post Office Savings Bank manual. It is a relevant portion of manual.
But if it was disconnected, Mr. Sinha will have a case. If it was discontinued from 1/4/1995 as per your manual, why did you issue it on 2002?
Yes, sir.
Now we cannot turn around and say that we are not going to pay you interest.
On this issue, Lordship, a consumer case was pending and it was informed to the petitioner, Lordship, that whatever outcome the consumer case happened, Lordship, on that basis, their case will be considered. At page 35. And page 35 is a consumer case, Lordship, it was dismissed. Yes. In this case, all the rules have been discussed.
This consumer case was by whom? Was it by you?
Not by them.
But since here also the issue was whether they will get.
Can you bring in a decision of some past in somebody else's case?
But the same issue, Lordship.
Issue may be the same. It is not a decision in rem, it is a decision in person.
So
how will it affect him?
Because in this case also the institution was not Lordship granted the interest, and this issue was before this consumer court.
That will it bind us? It will not bind us.
When the consumer court, Lordship, discussed this, even if it was wrongly opened. Even
Madam, are you relying upon a consumer court decision on a writ court? And he was not a party. If he was a party, we would have definitely said that you have to file an appeal. We just checked. It's by somebody else. But why did you first issue the certificate?
Because from 1995 it was stopped, Lordship.
Okay, we'll have to allow this. The approach to this court in exercise of powers under Article 226 of the Constitution of India has been made with the following relief. Relief to court. Full stop. As per the facts projected, the petition number 1 is a committee, and the petition number 1 is the secretary. Full stop. The petition number 1 had invested two amounts of rupees 10,000 each by purchasing KVP for the period of which was 5.5 years. And the particulars are as follows, it's numbered that we write. The KVPs were having a maturity value of rupees 20,000 each after completion of the stipulated period of 5.5 years. And those were issued on 31/5/2002. Full stop. After the completion of the 5 years and on maturity of the KVP, the claim was made for release of the matured amount, including the interest. Full stop. However, the same was not returned and returned. Full stop. The petitioners had also filed representations which were not responded to. Para. Sri Sinha, the learned counsel. Oh, I know, I've heard, huh? I've heard so insistence. Sri Sinha, the learned counsel for the petitioners has submitted that there is a clear stipulation in the KVPs for payment of the maturity amount on expiry of the period involved, and there is no dispute to the fact that such KVPs were purchased on 31/5/2002 and the maturity period was stipulated as 5.5 years. Full stop. He has submitted that the inaction, that the impugned action of the respondent authorities not to release the matured amount is absolutely illegal, arbitrary, and unreasonable, and also amounts to causing wrongful loss to the petitioners. Full stop. Para. For contra, Ms. Devi, the learned CGC, by referring to the affidavit in opposition filed on 2012-2024, has submitted that from 1/4/1995, there was a direction not to issue KVPs to institutions, etc. She has also drawn the attention of this court to the notification dated, to the Gazette notification dated 8/3/1995, by which the KVP within bracket amendment bracket close rules 1995 was notified, page 33. Full stop. As per the same, however, notified. Full stop. She submits that a similar matter was also the subject matter. A similar issue was also the subject matter in a consumer appeal, which was decided in favor of our clients. Full stop. Para. The private submissions, para. It is a certain facts are not in dispute, namely the issuance of the KVPs on 3/5/2002, and in the said KVPs, which were of the value of rupees 10,000 each, had a stipulation of payment of the maturity amount after completion of the stipulated period of 5.5 years. Full stop. The It is also not in dispute that the amount in question, including the principal amount, have not been released after the expiry of the maturity amount, after expiry of the stipulated period of 5.5 years. Full stop. The defense raised on behalf of the respondents is with regard to a notification, Gazette notification dated 8/3/1995, and some certain extracts of the manual which lays down manual. Full stop. Reliance has also been made on a decision of the Consumer Commission. Full stop. Para? So far as the notification dated 8/3/1995 is concerned, published in the Gazette, there is no restriction of any manner regarding issuance of KVP to an organization as such. Full stop. Under the amended part, such KVP would have been issued to a single holder type, to an adult for himself or on behalf of a minor, or to a trust. Full stop. So far as the reliance upon the scheme is concerned, it has been stated that issue of KVPs in the name of institutions / banking companies / local bodies was discontinued with effect from 1/4/1995. Full stop. Para? It is not in dispute that in the instant case, the two KVPs were indeed issued on 31/5/2002. Full stop. When the respondent authorities had consciously issued the said KVPs in spite of certain directions, in spite of certain statements made in the scheme that those were discontinued with 1/4/1995, the aspect of denying the benefit to the petitioners would not be justified at all. Full stop. The reliance upon a decision of the Consumer Commission is misplaced, as firstly, those decisions cannot be said to be binding on a writ court, and the decision otherwise also is not a decision in rem. Full stop. What is also of significance is that apart from the aspect that the KVPs were duly issued on 31/5/2002, the same had clear stipulation of payment of the matured amount after expiry of the stipulated period. Full stop. Under those circumstances, the action for withholding the matured sum cannot be held to be reasonable or justified. Full stop. Accordingly, the writ petition stands allowed by directing the respondents, more particularly the respondent number.
Respondent number 3 and 4, my lord.
3 and 4, to immediately release the matured amount to the petitioners on being properly identified. Full stop. Any further delay in release of the same would entail the respondents to be imposed with the aspect of interest at the rate of 18% per annum.
May please, Your Lordship.
18 years.
My lord, the petitioner happens to be the owner of a plot of land, my lord, at page number 12.
You are?
The pattadar, my lord, of a plot of land measuring 1 bigha, 2 katha, 10 lessons, my lord. Now, on 15/6/2023, my lord, the PWD officials, they constructed a road over my land, my lord. Lordship will kindly see the trace map. Trace map is at page number 22A.
Yes.
22A, my lord. Well, Lordship will kindly see the map, my lord. This road at dark number 20 was always there, my lord. But what they did was that, my lord, they constructed.
You're on page number
22A. 22A.
Yes.
This road, if your lordship will see the dark portion, my lord, this is the dark number 20. So this road was always there, my lord. When they constructed, my lord, they created the opening of this road, my lord, through the plot of petitioner's land, my lord. Now the thing is that, my lord, this road was, my lord, on the backside of the petitioner's land, separating it from dark number 19. 19, my lord. But while, my lord, construction, my lord, they created the opening through the middle, my lord, thereby bifurcating the petitioner's land in 2 portions, my lord. That is my only case, my lord.
What do you want?
My lord, on the first day, my
What
lord,
is the relief you are seeking?
my lord, on the first occasion, my lord, the interim was granted, my lord, staying the construction, my lord. So my relief, my lord, is at page number, my lord, 11.
So how
10.
How would the road be utilized by the public if the openings are not there?
Well, opening is always there, my lord. But the opening was not through my plot of land, my lord. It was, my lord, between my land and dark number 19, my lord.
But this diagram is not you cannot comprehend anything from
Yes,
this
my lord.
diagram.
In my reply, my lord, I have also annexed the photographs, my lord. My reply is at page number 34.
34. What page? Photographs at page?
Photographs at 44, 1 to 44.
When did you file reply?
My reply was filed on.
You get the reply. It's not there. Mr. Talukdar, reply is not there.
Copy of the reply.
When did you file? Have you served copies on the other side?
I have served, ma'am.
When did you file?
On 20th February.
Okay, we get coordinate with the registry. We'll have it with the records.
My
Heard. 3S Das Learned Counsel for the petitioner, who has informed this court regarding filing of a reply rejoinder affidavit on
20th February, my lord.
22/2026. Also heard Sri B.J. Talukdar, learned additional senior advocate, assisted by Sri P.K. Methi for the state, and Madam for Public Works Department. Then N. Das, I would like it. Miss M. Das, learned standing counsel, Professor PWD, and so and so. Okay. Have you received copies? You have received.
Then, my lord, I'll have to verify because, my lord, the e-court I have checked, my lord. It is also not showing, my lord, but I have an office copy, my lord. I'll have to verify it.
Okay. Equal property. Important. Positive. However, we'll also have to both Miss Das as well as Sri Talukdar, Learned Counsel, has informed this court that copies have not been received by them. Learned Counsel for the petitioner is to verify the said aspect. The matter may be listed along with the rejoinder affidavit. When?
Day after tomorrow, my lord. Today I'll verify, my lord.
On Monday?
Monday.
Okay, get the verification. On 23rd.
My lord. Highly obliged.
And you informally prepare a sketch so as to understand.
My lord.
Okay, just give a copy to them.
My lord.
Not with all those particulars. We only need the entrance part
My lord.
where to.
Our stand is, my lord, although he is owner of Doug number 21, he is occupying Doug number 20,
20.
through which the road goes.
That part will be at liberty to evict.
Yes.
But so far as his dog is concerned, that you perhaps you will not be able to touch unless you carry out some acquisition process, which you are not contemplating.
That's
My lord.
Monday we'll try to dispose this.
My lord.
Yes.
May please your lordship, the petitioner, the possession of the plot of land 214 lesas, ding down under Doug number so and so.
You're in possession of land.
Land and the said committee lordship, the application for the construction of the Mutation lordship. After verification of the documents,
You're in possession under what capacity?
the authority has
No,
permission
possession is under what capacity? Where you issued patta?
Patta lordship.
You're a patta holder.
Lordship. And the authority has lordship the permission for construction. And after 1 year,
Permission granted.
granted lordship.
Okay.
And after 1 year, they notice to the remove the construction lordship, after completion of the building lordship.
Notice to remove.
Yes, lordship. The permission lordship, page 13 lordship.
Yes, what is this file affidavit?
He is not a patta holder.
Oh.
He applied for the plot of land. He is occupying. It was in fact recommended in the year probably 2001. But subsequently, that was not handed over to them because of some encroachment. And then it was found that the land was, after verification, the land was reserved, vizier land. Therefore, lordship, after Jogpal, the allotment was not given to them.
Allotment was wrongly granted.
The lordship, the
Vizier land.
The lordship was the permission is granted lordship after the proper verification.
The permission will not give you any right.
The lordship.
Somebody may make some mistakes at some intermediary stage. No right will be acted upon you. You have to first show the basis is correct. Whether it's a land which is outside the vizier. Have you filed your rejoinder?
No rejoinder.
You have not even rebutted that was filed long back on 19/9/2025.
One time I filed rejoinder.
You filed rejoinder? When?
After a week.
Oh, you will file?
1 week time.
What rejoinder? This, if it's, let us see your agreement. It is by document. Where is it?
Lordship, the page 12 lordship. Land holding certificate lordship.
Sarkari Dagor. It says Sarkari Dagor dui kotha soiddhole ase.
Sarkari is not vizier.
Lordship.
If you say it's vizier, you have to make out a case of vizier.
Lordship is Sarkari. Lordship.
Sarkari, then you can take action strictly in accordance. Vizier matter will be slightly different.
No, matter is different, my lord. After lordship, what we say that after verification, it was found that the land is vizier. We have specifically stated it.
Grazing land.
Grazing land.
Thing, town, Kisam, Batadrava, Moza is grazing reserve. Dark 564 is grazing.
Grazing reserve.
They have admitted that, my lord.
Hmm?
Page 16, this their application.
16.
16. Paragraph 2. They say Jame Masjid was established over government vizier land by Dag number so and so.
Yes, yes, yes. What about 567? The Idgah? Your the cause of action is 564 or 567, both. Which one?
564
only.
564. The Dag number is 564.
Mr. Ahmed,
No, sir.
the subject is covered by 564 or 567.
564.
Well, 567 will not say anything. 564 will then dispose this of. Heard. 3 N. Ahmed, learned counsel for the petitioner. Also heard. 3 B.J. Talukdar, learned senior advocate, Assam, assisted by Sri P.K. Medhi. Anyone? Revenue is also party. Madam, revenue? Is it a party or? Not a party. Not a party. Okay. The instant writ petition has been filed with the following prayer, huh? Portfolio prior to. Full stop. As per the facts predicted, comma,
Revenue land.
the Dhing Town Jame Masjid and Idgah Committee possesses a plot of land measuring 2 katha, 14 lecha in Dhing Town Kisamat Dag number 564 under Batadrava Mouza. Full stop. The committee had made an application for construction of an RCC building before which board? Who had granted the permission?
The Lordship, the Dhing Municipal.
Before the Dhing Municipal Board. And it is contended that wide an order dated 22/12/2021 permission was accorded, whereafter the construction was made. Full stop. However, the board had thereafter issued a communication dated 3/5/2023 to the committee to produce the relevant land documents. Full stop. The documents were accordingly submitted along with a reply. Full stop. However, it is the contention of the petitioners that without granting any opportunity, the impugned order dated 24/2023 has been issued directing removal of the construction. Full stop. Accordingly, the instant writ petition has been filed. Full stop. Para 3. Ahmed, the learned counsel for the petitioner, has submitted that the permission for construction having been accorded by the Dhing Municipal Board, comma, the same indicates that all necessary verification was done over the plot of land in question. Full stop. He accordingly submits that the impugned action is unreasonable, arbitrary, and is not sustainable in law. full stop. Para, per contra, comma, Sri Talukdar, the learned State Council, has submitted that the impugned action is supported by valid reasons. Full stop. He has submitted that the land in question forms part of the is over dark number 564, which is grazing reserve. Full stop. In this connection, comma, the Learned State Council has drawn the attention of this court to the affidavit in opposition dated 19/9/2025, wherein it has been categorically stated that the land in question covered by dark number 564 of Dhing Town Kisam of Batadraba Moza is grazing land. Full stop. Though this affidavit in opposition containing such significant and important facts was filed on 19/9/2025, comma, no rebuttal affidavit has been filed by the petitioner. Full stop. Para. The aspect of lands under VGR PGR has been specifically dealt by the Honorable Supreme Court in the case of Jagpal versus State of Punjab, wherein the following observations have been made. Full stop. This court is of the opinion that an order of grant of permission to make constructions cannot be determinative of the fact that the land in question, determinative of the status of the land. Full stop. Sri Talukdar, the learned State Council, has also pointed out that the aforesaid aspect that the land is VGR is admitted, and in this connection, he has referred to an application dated 31/5/2023 issued by the petitioners to the Executive Officer Dhing Municipal Board, wherein it has been admitted that the establishment was that the construction was established over government VGR land by DAG number 564. Full stop. For any reference, the relevant statement made in the communication dated 31/5/2023 is extracted herein below, page 16. Yeah, sir. Para through. Full stop. Para. In that view of the matter, comma, this court is of the opinion that in the context of the seriousness of the aspect of maintaining VGR/PGR land as directed by the Honorable Supreme Court in the aforesaid case of Jagpal, comma, there is no scope for this court to grant any relief in this petition. Full stop. Accordingly, the same stands dismissed. Full stop. Interim order, if any, stands vacated.
Diplomat.
Item 20.
I'm appearing for F1 number 7 and 8 in this case, my lord. I'm saying 2 weeks time to file my reply, my lord.
My lord, a date may be fixed, not on after 2 weeks, my lord. In the meantime, we will exchange the affidavit. It may be fixed on.
But 24 matter, why haven't you filed affidavit till now, Mr. Alam?
My lord, not on last occasion, the matter has come up, my lord, we sought time for, my lord, but these documents are very old, my lord, of 99.
Okay, we'll grant time.
Yes, my lord.
But in the meantime, as Mr. Kalita has also suggested,
Yes.
that we grant more time, by which time further exchange.
My lord, it may be fixed in the last part of May, my lord. I have suggested a date, my lord, because I will be little bit out, my lord.
You tell us when do you want?
29th of May, my lord. Let it be come, let it come on.
How it's we PK
for a
Kalita Learned Senior Counsel, assisted by
K Talukdar.
A.
K.
K. Talukdar for the petitioners, full stop. Sri G. Alam, Learned Counsel for the respondent number 7 and 8 was granted time on the last occasion to file affidavit in opposition, and today he has renewed the said prayer for grant of further time. Puts the para as suggested, as agreed to by the Learned Counsel for the parties, matter stands adjourned to be listed on 29th
of May.
29th of May 2026, by which time further affidavits, including rejoinder affidavit, may be exchanged.
Yes.
Obliged.
Is there any interim order? No.
Lordship, may
Yes.
I make a mention, Lordship, item number 21, Lordship, as because it's already been adjourned. This case is listed at my initiation, Lordship. It was listed by order, but I have been told that the counsel who is appearing for the petitioner, he has already been appointed as an APP or PP.
Yes, we saw by order. We were wondering why was the mention made.
Lordship, as because Lordship, the writ petition was filed because of the non-payment of requisition compensation. And I have received instruction that the Deputy Commissioner has already received that amount. For disbursement of that amount, Lordship, this case was.
One lady was there, we not, she
But
was
if
not
it
on
that,
record.
Lordship, as because it is adjourned, may I pray for a preponement of that date, Lordship? If it
You
is
have
not-
that Learned Counsel, there was a lady.
No, somebody else has.
No, she was not in, she's not on record.
Yes, Lordship,
she's
that is why it is
She's
difficult.
not, we don't know her. New counsel. You get her, really get the date.
Or Lordship has fixed it on 30th of March. Lordship, my name may be reflected in
Yes,
that case,
it's
Lordship.
Kunal
On that case,
Silva.
Lordship, an handover will be made.
Huh? Aparna. তাতে এটা লিখি দিলে হ'ল।
If it is not difficult on.
No, we'll put up one line. 3H Sharma. No, later on, huh? Later on. 3H Sharma, Learned Edition Senior Advocate, has, however, informed that there are subsequent developments, including receipt of the amount involved by the Deputy District Commissioner, and the matter itself can be sorted out. On the next date, the name of 3H Sharma, Learned Edition Senior Advocate, be reflected in the court list.
I'm sorry, Lordship, for mentioning.
No, that's okay.
22. May I plead your Lordship? Lordship, kindly pass over the matter for time being, Lordship.
What is the matter, madam? Revenue?
It's also easier than mine.
It was.
If it is easier, it will go, madam.
They have not filed any reply.
99, 20, 25, yes. Yes, let Mr.
Lordship, kindly pass over the matter.
Yes, let him come, let Mr. Chaudhary come. In the affidavit, you have stated in details. After a while. On behalf of whom? Ardhar. Mr. Islam, for a while. He was there sitting, where has he gone?
This matter is under Jamindari Act, my lord. The land which was taken over in 1957.
Madam, affidavit filed.
Yeah, affidavit has been filed, my lord. And we filed a reply to.
Huh?
We filed a reply also, my lord.
We have it for admission hearing then.
Yes, my lord.
We can have it on before Bihu?
Before Bihu, my lord. Yeah. No, before Bihu.
Before Bihu, the last week would be motion week. And ninth,
let it be-
ninth is a declared holiday now.
On 30th.
Everyone is very happy.
But on 31st, my lord. March.
No, my lord, after Bihu.
After Bihu, my lord, it's a small matter, my lord.
Small with this bulky brief.
But I will
We can even
I'll make it short, my lord.
Huh?
Because the compensation officer, my
Brief is of how many pages?
volume is, my lord, but
800 pages.
but useful thing is that, my
How
lord,
many pages, madam? Biggest brief.
it's a, my lord, my lord, the honorable district judge has passed the order. Then the High Court has passed the order.
536 pages, see?
No, I'm just giving a small brief, my lord. Here is the case, my lord. Compensation officer decided
Briefs
that
are small only. How can briefs be? Can it be a brief? Brief itself means small.
your lordship, for your lordship, is
What
very
is a
small,
small
my lord.
brief?
But it's a non-consideration of representation in proper manner.
Okay, well, tell us a date.
31st, my lord.
Immediately after Bihu.
It will be late, my lord.
What date? It's a 25 matter. We'll go after the.
It's pending for 70 years, my lord.
So when did you come to the court?
When I came,
You came in
but they
25.
remain
Okay,
silent.
we'll have it on 22nd of, no, 21st or 24th of,
My lord,
23rd of April.
there is so many litigations, my lord. People die.
23rd.
Now the legal heirs, they have proceeding, my lord.
23rd of April for admission hearing. It's a Thursday.
The 23rd April, my lord, I'll be traveling, my lord.
21?
21, yes, my lord.
21, madam? Okay.
21.
Okay. Heard Sri J. Roy, Learned Senior Counsel, assisted by Sri. Okay. BP Sharma.
Lordship.
Dr. Gogoi is also here. For whom?
I'm assisting my secretary person.
Okay. Also heard Sri N. Goswami, Learned State Counsel, as well as Miss P.R. Mahanta, Learned Standing Counsel. Revenue Department, full stop pleadings have been exchanged, and the Learned Counsel are in agreement that the matter can be taken up for admission hearing. Full stop. Para, list accordingly list for admission hearing on 21st of
21st, madam.
April 2026. Okay.
Endeavor will be made to dispose of.
For admission hearing, you said. Come prepared.
I'll
admission
come
hearing.
prepared.
Madam, come prepared. Don't pray for adjournment. Yes. Item number 20.
May I please, Your Lordship? Lordship, for a movement, kindly have a look at of last order dated 10/2025, Your Lordship. Your Lordship, inspection was called for, up to date inspection was called for.
Yes, what is it?
That amount was sanctioned but not released because fund was not received. Lordship.
Ex gratia.
Lordship.
How much amount?
1 lakh.
For?
For husband of the petitioner have expired due to drowning, Your Lordship, as per all notifications. That
Amount has been sanctioned already.
Yes, Lordship. In
So
the
why
month
not
of
paid?
2000, in the month of September 2022, but it has been not released yet, Your Lordship.
That instruction is of which date, Mr. Goswami?
October, Lordship, last.
That was already recorded.
Yes, it's recorded, Lordship. Right.
Why is this in a contempt case?
Because your lordship, as per the direction of this honorable court, district commissioner may be verified, shall verified and forwarded to the revenue department for release the amount. But we have filed contempt petition because we have communicated with the district commissioner, they have lying unattended. Therefore, we have filed contempt petition, and contempt petition also dispose of because district commissioner
But
already
you were
verified
directed to have
and
the
the same.
instructions. You are directed to have the instructions way back in October 2025.
Subsequently, we have sent the letter also, but not.
Letter would come from whom? Response would come from whom? District Commissioner. Kamrup, Amingao.
Yes, lordship.
What is he doing?
But Pan had to receive from the lordship revenue and disaster management department.
That letter is of September, Mr. Usami.
Lordship.
That is the position which you have stated before the court in October.
Subsequently,
Thereafter,
we have sent the letter, but.
so he will not respond.
Several time budget has been allotted, but
If he doesn't respond, he will come to the court. He will respond directly to the court.
absolutely.
Sufficient time has elapsed.
Yes, yes.
There may be a difficulty, but it has to be communicated to you, then from you to the court.
Yes, yes.
Because you cannot just sit tight like this. Heard 3SI Akan Learned Counsel for the petitioner, whose claim in this petition is with regard to payment of ex gratia. Full stop. This court on 29/10/2025 had recorded the submission of the Learned State Council that the sanction was made for the payment in September 2024. Full stop. This court had, however, directed the Learned State Council to have the status on the next date. Full stop. Para. Though Sri N. Goswami Learned State Council has submitted that communications were made to obtain this present status, comma, the same has not been responded to. Full stop. Para. Matter since 29/10/2025, when such direction was issued, comma, sufficient time of more than 11, 12, 1, 2, of more than 4 months has elapsed, and it is a matter of concern that there is no response. Full stop. As an exceptional circumstance, comma, further time is granted to the state respondents to respond to respond and give the up-to-date status. Failing which, comma, this court will have no other option but to have the concerned officials personally present in the court. Para. List on on 25th of March.
I'm sorry.
Lordship, may submit one thing, Lordship, that Pan has to receive from the revenue and disaster management office.
You have to tell us, where have you stated?
In the instructions there.
Where instruction is of September, we said that the status as on today. That instruction was taken into consideration when this court had passed the last order in October.
Lordship.
So we want to know what has happened thereafter.
I'm deeply.
You may have difficulty in paying, but you have to tell us officially.
So,
And 1 lakh rupee, what is the difficulty?
25%. Lordship.
When you are spending crores and crores of rupees. Yes. Mr. Dhar, what is this?
My lord, here the case of the petitioner is that Deputy Commissioner has, my lord, has rejected his application for grant of caste certificate.
Deputy Commissioner has?
Rejected, my lord, reverted back.
Okay.
My lord-
You applied for a caste certificate.
Lordship.
You belong to which caste?
Mother, his subcaste. Mother, his sub-tribe of Raga tribe is called under the STP.
STP.
Kind of.
You claim that you belong to STP
STP.
and you applied for a caste
Applied for
certificate.
caste.
That has been
Rejected.
rejected.
But there is a notification.
My lord will come to page 83, the impugn order that is
83.
page number 83 of the writ petition, my lord.
Yes.
My lord will find status reverted back. On top of it, my lord, official remark, comment, supporting caste certificate to be submitted. Page number 83, my lord. Down to
Yes,
the
yes.
reverted back status.
Revert back. Did you give the supporting caste certificate?
No, no, father's not certificate. Father's caste certificate is not there. I have not certificate, but
Then-
there is option, page 45 candidates.
45.
Office memorandum of adoption. Our fathers did not obtain certificates.
Then how do you substantiate?
Page 45 candidates.
Not only that, my lord.
Just a minute.
My lord will come to page 45. 7.
7 years.
This is, my lord, mandatory. I am just reading, my lord. Applications are to be submitted by filling up the online application forms and attaching either one, the caste certificate, tribe certificate of the father of the application, or the identification certificate issued by the authorized caste tribe organization. This is very vital. Why vital, my lord? Just this came up.
Do you have anything? Have you given anything?
Yes, 45, 65 years.
65. What is it?
It is the All Assam Tribal Sangha.
65. What about this?
They said that we are.
No. What about this, Mr. Dhar?
My lord, I'm coming.
There are two options.
65, 65.
One is the caste certificate of the father, and the other is an identification certificate issued by the authorized caste tribe organization.
My lord.
65, 66, 67. 3 petitioners.
My lord, I'll just continue reading this para 7.
Yes, please.
Down below, from below top 4th line, my lord. In case of any doubt on the identification certificate issued by the caste tribe organization,
Yes.
the DC will cause an inquiry through the circle officer. However, the inquiry is to be limited to ascertain the caste identity and not for producing data, etc. My lord. So, my lord, here DC has rejected. My lord, we have seen, my lord. Basically, my lord, caste certificate, my lord already has dealt with Navakumar Shoronia case, my lord. There also, my lord, the father's, my lord, certificate is very essential to, my lord.
No, Mr. Dhar, you are not on the issue. There are two aspects.
My lord.
One father certificate, the other is from the organization. If you are having any doubts with the certificate issued by the organization, you cause an inquiry, matter ends there.
But I want to make part.
His entire claim is not on any further certificate. Admittedly, he is not in possession of any further certificate.
My lord.
He has a certificate issued by the concerned organization.
In this,
If you have any doubt, make an inquiry in accordance with this notification.
3 petitioners, not only one. His cause shows is 3 petitioners.
You have 3 petitioners.
65, 66, 67, 3 certificate I have finished. And all Rafa student organizations also issued certificate that we are that Madai subcaste is. And your lordship is 40 notification.
You are equipped with 3 certificates. You cause an inquiry, finish the matter.
My lord will then direct deputy commissioner, my lord, to ascertain it.
Mr. Goswami, the matter is not so difficult. See, to issue a caste certificate, he has to be equipped with his father's caste certificate or a certificate from the concerned organization. Admittedly, in this case, there is no father's caste certificate. He is depending on an organization's caste certificate. The further safeguard which is given is that if you have a doubt on the authenticity of such certificate, you can get it verified by an inquiry done with that organization. Now, you have rejected with the ground of additional supporting documents. He says that supporting documents are already given. You can cause an inquiry if you find that that certificate which has been issued by those organizations in favor of the petitioner are correct, authentic, issue him. If you find that those are not authentic, reject it. Okay,
And my lord, may I make another submission?
please, please.
My lord, in case deputy commissioner has another option also, my lord. If he is in doubt, my lord, he can always refer this to the Caste committee.
No, see, Mr. Dhar, that aspect will come when you dispute somebody's certificate. Here is a case, it is not a dispute. It's at a threshold, whether to issue or not to issue. If somebody is aggrieved tomorrow that this issuance is not correct, then he can challenge it.
Yes.
Then he'll go before the committee, okay?
Page 35, your lordship, page
30?
35.
What is it?
It is the census of India, 1961. Admission in respect of Assam.
No, we are not on those. We are not on
Our
those.
name is there yet.
We are not on those.
This, that's.
Third, Sri S. Islam Learned Council for the petitioner. Also heard Sri R. Dhar, Learned Standing Council, Tribal Affairs Clean, as well as Sri N. Goswami, Learned State Council. Para? Considering the subject matter involved and as agreed to by the Learned Council for the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Para? As per the facts projected, the petitioners, who are three in numbers, belongs to the inverted comma Madahi Madhi subtribe Madahi inverted comma of Rabha tribe, which is a scheduled tribe within bracket plain in Assam. Full stop. The petitioners had accordingly submitted online. Please have your seat, Mr. Islam. Has submitted online applications on 6/1/2025 and 7/1/2025 before the concerned district commissioner, Kokrajhar, for issuing such STP within bracket ST within bracket pre-certificate, and they claim of enclosing all relevant documents, including the certificates issued by the concerned organization as per the office memorandum dated 8/8/2022. Full stop. However, the applications have been rejected on whimsical grounds. Full stop. Para? Sri Islam, the Learned Council, has submitted that as per the official documents, Madahi subtribe of the Rabha tribe is a scheduled tribe plains in the state of Assam. He has also drawn the attention of this court to the office memorandum dated 8/8/2022, as per in which, comma, the procedure for granting such certificate has been laid down. Full stop. It is submitted that the father's caste certificate is not the only requirement prescribed, and there is another option where an identification certificate can be issued by the authorized caste/tribe organization. Full stop. He submits that in this connection, the authorized organization has given due certificate, and without considering the same, comma, the rejection has been made. Full stop. He has also submitted that the remark in the rejection, which has been made online, is also incorrect regarding the aspect of submission of supporting documents inasmuch as such supporting documents were already enclosed to the application. Para 3. The learned standing council has submitted that as per the office memorandum dated 8/8/2022, there is a requirement of such application to be enclosed by the caste/tribe certificate of the father of the applicant. Full stop. Here, however, fairly concedes that an identification certificate issued by the authorized caste/tribe organization can also be considered. Full stop. Full stop. A perusal of the application submitted by the petitioners would show that those were also enclosed by the relevant documents, including the certificate issued by the relevant organization. Full stop. This court has carefully perused the office memorandum dated 8/8/2022, which lays down the procedure for grant of such certificate, and it is not in dispute regarding the operation of the aforesaid office memorandum. Full stop. This court has also noted that in case the deputy commissioner, within bracket district commissioner of the concerned district is having any doubt on the authenticity of the caste certificate, either of the father of the petitioner or the certificate issued by the organization, the deputy commissioner may cause an inquiry through the circle officer. There is also a stipulation that such inquiry is to be limited to ascertaining the caste identity and not for production of data, documents such as NRC papers, etc. Full stop. For ready reference, the procedure laid down in the OM dated 8/8/2022 is extracted herein below, page 45. Next page. Para. As noted above, there is no dispute to the existence of the aforesaid OM dated 8/8/2022 and the same being in operation as on today. Full stop. Para. This court is of the view that when the procedure laid down also contains a further step of causing an inquiry in case of any doubt with the identification certificate issued by any organization, that the same can be inquired, the aspect of rejection of the application without causing such inquiry does not appear to be reasonable and justified. Full stop. The writ petition accordingly stands allowed by directing the concerned district commissioner, which district? Pokrajhar, to strictly follow the procedure S9 laid down in the OM dated 8/8/2022, and in case of any doubt with the identification certificate issued by the organization, cause further inquiry through the circle officer in the manner prescribed, and thereafter take appropriate action in accordance with law. Full stop. The aforesaid exercise be undertaken and concluded expeditiously and preferably within 90 days. 90 days from the date of receipt of a certified copy of this order. Repetition stands allowed to the manner indicated above. Yes, next.
26.
It takes a lot. Before my reference third, my lord, may I make a prayer for time being, for pass out a matter for time being, my lord. For respondent number 7, Mr. Keynes is appearing before lordship, my lord.
In that
He's-
case,
he's-
he's
he's
can it
late
be on a
order.
hearing day, my lord? Some judgments needs to be placed, my lord.
My lord.
I will have it today. We fixed it today.
Yes.
After a while.
Yes,
My
my
lord.
lord. Deeply okay.
Yes. What is it?
Loss, my lord. Only on last occasion, my lord, the ICICI bank appeared, my lord.
ICICI.
ICICI.
Who's the counsel? Names not shown, Mr. Raman. Who had appeared? Any idea?
But I have forgotten his name, my learned friend.
No, not appeared. Nobody has appeared. The order sheet does not reflect that anybody had appeared on behalf of ICICI. Rather, it says that are yet to be notices, service is yet to be complete.
We have already taken, my lord, we have already taken steps, but the problem is that there is no standing counsel from the ICICI
No,
bank.
but can you try with Mr. M. Sharma? He normally appears. M. Sharma. Let me non-episode service.
Then, my lord, we can serve the notice to him, my lord.
Just a minute. Notice, speed post, unserved notice. Can you request Mr. M. Sharma to have M. Sharma? What is his full name? Mr. Handik? Mukesh Sharma. If he's around in the court, you can request him to come to the court. He is not a standing counsel as such, but this will expedite your matter. Okay. You try to bring him into the court. Or we can have it day after tomorrow. In the meantime, you inform him. Okay. Third, 3 SSE Rahman Learned Counsel for the petitioner. Full stop. As there is no representation from the ICICI Bank, matter is deferred till Wednesday. We are not reflecting anything in the order. You informally ask him to appear, okay?
Higher obligement, higher
M.
obligement.
Sharma.
Lordship, can it be taken to Friday with clothes?
What is the matter?
My lord, kindly have a look on 34 to get the periodic patta, my lord. Already they have undertaken before this honorable court. They showed only next of kin certificate. We have submitted next of kin certificate. Despite that, my lord, that we are waiting, my lord.
My lord, that verification is going on. My lord, due to some problem of the LRA lordships, and the my lord, that the officer of the that Sonapur Revenue Secretary has been transferred lordships. The new incumbent will join today or day after tomorrow.
Okay, we'll grant some.
Yes,
time.
my lord. Yes, my lord.
And my lord, that the LRS have told me that my lord, that there is some problem, my lord, because my lord, that they are positioning that they said land lordship. Some of the outside of the person lordship, they recorded their name in the said land lordship.
Have you filed your affidavit? You have
No,
not
Lord,
filed.
my lord, that instruction I did not have.
You filed your affidavit. That will clear the matter.
Lordship, lordship. It will better.
Yes, matter. Date may be fixed.
Third, 3 PK Decca Learned Counsel for the petitioner. Para. 3 J. Hendrick Learned State Counsel has, however, renewed his prayer for grant of some time, as there has been certain changes in the post, changes in the changes of the respondents, of the incumbents holding the post of the respondents. Full stop. Para. How much time?
2 weeks, little better.
Yes. That
On
may be-
request, matter stands adjourned by 2 weeks to be listed on 2 weeks, 2 weeks, 1, 2. When? Can we have it on third is a holiday again.
What is your holiday?
And last week, out of 5 days,
Last,
last week it will be difficult.
Lordship.
Out of 5 days, 1 day is gone, 9th is gone.
But the 1st of April,
1st of April is possible, 1st of April.
I will try.
1st of April.
deeply oppressed.
Yes.
Lordship, I have applied for electricity connection on 15/11/2025. Your Lordship will find the page number 36 is my online application acknowledgement receipt. And thereafter, Lordship, since the electricity has connection.
There is an objection by one Mintu Gogoi.
Yes, ma'am.
Yes, but there, Lordship, in whichever the document I have relied for electricity connection that not substantiate the any interest of Mintu Gogoi, because the land has been absolutely possessed by the petitioner, and the Miadi Patta has been granted by the deputy commissioner. And so far the new development is concerned, Lordship, the office of the Lordship district registrar, they have also, Lordship, they provide me, Lordship, non-incumbent certificate, and they have.
How
also,
is this objection relevant, Mr. Das?
My lord, since they're claiming to be the absolute owner, my lord, so as part of our regulation, they have to submit the proof of ownership. Ma'am.
I have submitted, Lordship.
And
Everything
if
is
we have
there.
received the objection, my lord, this is only the procedure. If the court directs, my lord, we can grant the millings.
No, see, Mintu Gogoi is not a party. At the same time, we cannot take cognizance of every complaint. He may not have any interest.
Yes, yes.
So you have to prima facie show.
Yes, I have the that document.
Where page?
Lordship, Miadi Patta is, Lordship, page number 13. Starts from page number 13. This is the Patta, Lordship.
Hiran Gogoi and Jayantajit.
Yes, your Lordship.
Who is Mintu?
Mintu is not there, Lordship.
No, who is Mintu? Your brother?
He is not my brother, Lordship, cousin brother.
Cousin.
And your Lordship will find page number 22 is the Jamabandi, Lordship.
Now one temporary connection has been granted to you.
Temporary connection has been granted, but subsequently that has been disconnected because it needs, Lordship, Lordship needs to make a certain amount for that continuation of that connection, Lordship, that is so. And so far the Lordship, now also the Land Revenue Department has also, Lordship, allowed me to allowed my application to pay the Lordship Khazana, and also it is declared that it is encumbrances free, Lordship, on 12/3/2026.
But Mintu is not before us. That is the problem. Where is your ex? Where is your report? Report has been marked as X, isn't it? Last time you had given the report, Mr. Das.
Yes, ma'am. Well, I can give one more.
We have.
Yeah, my lord, we have also received a legal notice from an advocate that is also before your lordship. I placed it, my lord. I can.
Is 17.
No, my lord,
That's on 18
I
of
have
this, sir.
completed a copy of objection. That I can be on.
It was not addressed to them, lordship.
Objection, my lord, that we have received.
The aspect of ownership, we grant of electricity connection will not determine. They will be at liberty to determine that aspect in the appropriate court, where the petitioner will be given the scope to, he'll have the scope to contest. But ideally, Mr. Sharma, you should have made this Mintu Gugoi a party.
Lordship,
Because you knew that it is because of his objection.
Lordship, in this
And
regard.
he's serious in his objection. He's served a ETCPC notice to the government, director, district commissioner, that he's instituting a suit. Probably he's already instituted. This is 22/10/2025. Has any suit been filed against you?
Lordship, this is the non-incumbent certificate. It is issued on 12/3, Lordship. This month, Lordship.
No, that is different
By the Deputy
matter.
Commissioner, Lordship.
So you may be equipped with the documents,
Yes,
but
Lordship.
somebody is disputing.
Yes, Lordship.
So that dispute has to be adjudicated.
Yes, Lordship.
And will be adjudicated by the appropriate court. But this legal notice is of October 2025. Has any suit been instituted against?
No, suit is pending before, because if suit is pending, that no granting of non-incumbent certificate, that does not arise, Lordship. Because it has been granted on Lordship 12, Lordship. And the settled position of law is that Lordship company, since the company cannot decide the title, and therefore Lordship division bench of the Lordship Gujarat High Court clarified that Lordship, since the dispute cannot be decided by the company, therefore Lordship electricity connection cannot be denied to the Lordship possessor and the owner, Lordship.
DC connection has never been denied. Temporary connection was there, but they have applied for only for 10 days. Because of which it was disconnected later.
The decision, only the decision.
But they are asking for permanent connection.
There are 8, 9, and 10, Lordship. Division bench judgment is referred under para 6, Lordship, paragraph 6.
Okay, we'll come back at 2 o'clock. So there will be some delay. We are having some meeting in the fourth recess. Okay. Yes, Mr.
Your Lordship may kindly refer the judgment of Yogesh Lakman Bhai Subhatia. Your Lordship will find at paragraph 8, Lordship. I have referred the paragraph 8, 9, and 10, Your Lordship. May I read, Lordship? The Honorable Court has relied the division bench judgment in paragraph 8, Lordship, that in the present case, the counsel for the appellant has failed to show that any provisions laid down under the law or guidelines for allowing a company to recover its due or by seizure of property or by any auction sale of such property for which condition is imposed on consumer to show right or title in giving
This is
electrical
an
connection.
entirely different context.
Yeah,
This is an entirely different context. It is with regard to seizure of property
Yes,
in connection with recovery of dues.
But
So unless you have the expertise to decide determine the ownership of property, you cannot seize. On that context, it has been said.
Yes, Your Lordship, but Your Lordship may kindly come to paragraph 9, Lordship. Does
So
the
9 is the
petitioner-
division, not a division bench.
Yes, Your Lordship.
9
but-
is not a division bench. You are relying upon 8, which is a division bench said on a different context.
And also, Lordship, in a judgment of the Lordship, Delhi High Court, Lordship, Your Lordship will find a paragraph 12, Lordship, that it is clarified that grant of electricity connection or disorder would not confer any special equities in favor of the petitioner, would not constitute by as conferring or recognizing the title of the petitioner of the said property with regard to the identity of the said property, Lordship. When his petition was allowed, Lordship, this observation has made, Lordship.
So how does it help you? We may make a similar observation. You are on a different context. That,
But Lordship, in my case, Lordship,
that
it is-
because you have the ownership, this documents.
ownership documents, Lordship, I have enclosed, Lordship, because Miadipatta is a Lordship ownership document, Lordship. Miadipatta and Jamabandi is also a Lordship, this document which Lordship. also
But there
required
is
for
a
the
dispute, there is a dispute to that. And you have not made that incumbent a party respondent here. That is the only difficulty.
Lordship, since he is not in any way connected in the plan documents, Lordship, therefore, Lordship.
But you know why was it disconnected?
Lordship,
You know why was it disconnected?
Lordship, not disconnected, Lordship, not provided till today.
No, the issue that your claim to have a permanent connection instead of a temporary, that has not been done because of what reason? You know the reason.
Lordship, only because of that objection which has been received by the Lordship respondent side, Lordship, only they have informed before the Honorable Court, and then only, Lordship, it came to the knowledge, Lordship, thereafter.
In fact, my lord, the objection that I placed before your lordship, they have submitted a Jamabandi, my lord. In that Jamabandi, the Mintu Gogoi's name is there, my lord. So we are.
You file an affidavit. You file an affidavit. Heard Sri D. Sharma, Learned Counsel, for the petitioner. Also heard Sri B. Das, Learned Counsel, for the APDCL. Full stop. On the last occasion, i.e. 6/3/2026, the Learned Counsel for the APDCL had placed before this court written instructions from where it reveals that one Mintu Gogoi has submitted an objection claiming absolute ownership of the premises in question. Full stop. Let an affidavit be filed by the APDCL. APDCL?
Yes, my lord.
APDCL in this regard, for which, how much time? 2 weeks? For which 2 weeks time is granted. We have it before the bifurcation?
My lord.
Possible?
Possible.
List on 6th of April? 6th of April.
In the meantime, Lordship, temporary connection that might be allowed to continue.
You are having
They
the,
have to apply for that, my lord. Earlier, they have applied and only for the 10 days, my lord.
in the meantime, if the petitioner applies for renewal of the temporary connection,
Press connection.
for grant of temporary connection, along with relevant documents, and in the prescribed manner, the same is directed to be considered.
Highly blessed.
Can you write? Mr. Das and Mr. Sharma, take those. You can place it on the next occasion. Das or econ legal document. Or yes, log it out. Sharma.
My lord, I have gone through this 127, my lord. May I just for a moment, my lord, allow to, my lord? 127.
Yes, please.
More like, 127. Let me kindly turn to page 133, my lord.
Yes.
Constitution of Panchayat Election Tribunal.
Yes.
The government shall constitute such Panchayat Election Tribunal as may be necessary on the recommendation of the High Court to dispose of all direct election petition challenging election under this Act. So, my lord, here is a word, the direct election has been used, my lord. So my limited understanding, my lord, is that the elections regarding the ward members perhaps, my lord, come within the purview of this direct election phase, my lord. Now we are, my lord, here is a case, my lord, wherein we are challenging the election of the president as well as the vice president, my lord, which is an indirect mode of election by the ward members, my lord. So, my lord, it needs some.
All this
The second part of the 127.
My lord, my lord.
Exemption is only on section 10, my lord.
The jurisdiction, powers and functions and headquarters of the
See,
tribunal.
that is why we have to read 10.
My
10 says any dispute relating to the validity of election
My
of the president and the vice president of Gaon Panchayat.
Gaon Panchayat, that is correct.
That
Because-
is barred.
Because of section 11, my lord.
That is barred.
That, my lord, under section 11, we can go to the deputy commissioner objecting, my lord. If we do not, then we can come before my lord, my lord.
Yes.
But, my lord, here is as the word, my lord, direct election has been used. So, my lord, though exception has not been provided, but the entire reading, my lord, perhaps clarifies that it should be, my lord, for the ward member level, then we can go to the tribunal, my lord.
So how do you get your such a dispute resolved? Where? Which will be the
My
forum?
lord, the dispute is very limited herein.
No, where do you get the where will you get it resolved?
My lord, the authority concerned, who is now, my lord, regarding the, my lord, the holding of the first meeting. If that authority, my lord, do not hold the meeting in a proper manner, my lord, then the higher authority to them can look after, my lord, because this is an administrative exercise.
No, unless the act prescribes an appellate kind of an authority.
My lord, my lord.
It will only be a represent. There is no bar in law for consideration and passing orders in a representation.
My lord, my lord.
But as of right, if you claim, there has to be some prescription in the act or the rules.
Yes, yes, my lord, that, my lord, I cannot show that provision is not there, my lord, for the purpose of Anchalik Panchayat. But, my lord, if we go to the election tribunal, then the disputed question of facts is required to be decided. Now, my lord, here is a case wherein the number of votes, who got how many, it is a matter of ballot is there, my lord. They can examine, my lord.
Mr. Dutta,
My lord.
how do you address this? All direct election petitions?
My lord, in the act, my lord, for section 10 only, there are specifically power to give
11.
to the 11, under section 11, district commissioner has the power. Otherwise, government or district commissioner doesn't have any power, my lord. And this is not a, as per numbers of judgment there, it's not a fundamental right, man. It's a constitutional right, man.
So not even a constitution, it's a legal right.
Yes, my lord.
But how do you have to resolve this? He has raised an issue. The dispose of all direct election petitions. What is the meaning of all direct election petitions?
The definition of direct election is not in the act, my lord. But as my lord, section 10 is also included in the 127. Mere reading of this section, my lord, it's prima facie shows that the Anchalik Panchayat and Zilla Parishad level excluded, my lord.
Okay, we'll have this when? Tomorrow or on Thursday?
My
We'll apply some mind.
Or if I can get some case laws.
Okay,
my lord,
okay.
I'll also try to find
Okay.
out.
Okay. We'll have it when? Tomorrow? Can we try?
My lord, can it
Tomorrow.
be-
Tomorrow or tomorrow, my lord.
Tomorrow. On a joint request.
Tomorrow, so sorry, my lord. Tomorrow I have some problem, my lord.
Thursday.
Thursday, my lord. Thursday.
On a joint request made by the Learned Council for the parties. Matter is deferred for consideration till Thursday.
My lord,
Till Thursday, list for motion on
19th.
19th.
I know.
Deeply obliged, my lord.
Please, my lord.
Yes, what is this in person? What
There
is
is a
this?
non-payment of bills, lordship. They have paid already.
We have already paid the amount,
on
What was the
2022.
amount for?
about 70 to his professional fee also.
Already paid. So
Paid,
you
lordship, paid.
withdraw this.
Yes, lordship.
Okay. Heard Sri P.J. Burman, petitioner in person, who had approached this court with the complaint of non-payment of bills for the functions which she had discharged as special public prosecutor.
Yes, Lordship.
In the court of the Municip number 3.
Yes, Lordship.
Kamrup M. Full stop. Notice was issued on 13/2/2026. Para. Sri Burman, the learned, no, Sri S.C. Kyle, the learned. You appear as?
Actually, standing counsel for income tax courts.
Standing on the Income Tax Department has, however, informed that in the meantime, the bills have been cleared. Also heard Miss A. Gayan, learned CGC. Para. Sri Burman, the petitioner in person, has acknowledged, has not disputed the aforesaid fact and has rather endorsed the same. Full stop. In view of the above situation, this court is of the opinion that there is no surviving cause of action which requires any adjudication. Writ petition accordingly stands closed.
Highly objected.
Good.
Maybe, Lord.
Yes.
This case, my lord, last occasion, my lord, respondent authority was directed to file affidavit, my lord.
What is the cause of action?
So, my lord, petitioners, my lord, is a venture, my lord,
You have applied for allotment of land.
Yes. A proposal also made, my lord, but thereafter,
17 bighas.
my lord.
Then what has happened?
Proposal, inquiry was made, my lord, thereafter proposal also made, but the district level, my lord, sub-division level committee, my lord, not considering the petitioner's case, my lord, till date, my lord.
Yes. Mr. Goswami? Is he there? His instructions have been received. After a while.
Item 66, subsidies.
May I please your lordship? Lordship, I beg to mention that there are some error in my petition, affidavit in reply. That's why I want to correct the affidavit.
Not allowed. Madam, why are you making the same submission? Some other counsel was there on the last occasion. We had rejected your prayer. You have made a false statement on affidavit. We want to proceed against your client. And false statement knowing to be false. You have said even one of your siblings is dead only because of a property. We are not going to tolerate this kind of things in a writ proceeding. You have been served copies. Where is Mr. Ahmed, who appeared on the last occasion? FKR Ahmed appeared.
He is in other court.
What is this order number 100? Mr. Roy? Are you required to file an undertaking at the time of filing of pleadings? Even if you serve the, even if you serve. If you do not serve, then also undertaking is required. Okay, that you have served, you have to give an undertaking. So what is the objective of the notice accompanying the affidavit or pleadings? Notice has a receipt copy. Notice has the receipt, acknowledgement of receipt.
The format given by the registry to give us the undertaking, if it is not served to other councils, then you have to give an undertaking.
No, that is the scenario when you are not being able to serve. When you serve,
They take the, along with that you have served, or you are taking the undertaking, you are giving the undertaking. That was the given by the registry.
now who, okay. Okay, when should we consider this? When is Mr. Ahmed is able to come? We'll have day after tomorrow, madam?
Yes.
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Wednesday. Ms. T. Goswami, learned counsel for the AFC, and 3 SS Roy, learned state counsel. No, this is finance department. And who's for finance department? H. Aliha, is he there? And 3 H. Aliha. No, episode na lagi. T. Goswami for AFC is present. And T. Goswami and SS Roy na lagi. Whole T. Goswami is present. Okay, Wednesday. We'll have it on day after tomorrow. Motion nahi.
Sir, responded 26.
Oh, sorry. Before my learned friend starts, Miller, we have raised the issue of maintainability of the writ petition. If your lordship permits, I can address your lordship.
Yes.
Sir, first, Miller,
Mahanta is for the petitioner.
I'm the petitioner, my lord.
Okay. You're for as per number
7, my lord.
R7.
if your lordship should kindly come to Article 243O, Miller.
Constitution of India.
249.
Article
243 capital O. It starts with a non-obstante clause. Notwithstanding anything contained in this constitution, the validity of any law relating to delimitation of constituencies or allotment of seats to such constituencies made or purporting to be made under Article 243K shall not be called in question in any court. We are not concerned. D is important. No election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as may be provided for by or under any law made by the legislature of a state. It is perimetria to my lord, Article 329 B. Now, my lord, if your lordship should kindly take the Act, Assam Act, my lord. Here from the scheme of the Act also I will demonstrate that there are situations where end of the day, my lord, the allegation is I do not have the qualification. Required qualification.
You are what? R7 is
Sir,
elected?
Is a member of the Panchayat, my lord. Anchalik Panchayat.
Elected member.
Yes.
And president as well.
And president. No, first I am a member. Now the issue is regarding my membership. The issue regarding my presidency is not an issue in this case. Now, therefore, assuming, my lord, if we construe the case projected by the petitioner, then it's a case of improper acceptance of nomination paper. That means a person is not qualified. Now he has been, now, my lord, I fought the election I own. Now, therefore, under the scheme of the Article 243O, read with, my lord, section
127.
129B, 129B, my lord, an election petition would lie. Please come to 129B for a moment. Yes. First, my lord will kindly come to 127, then 129. Tribunal hai to be like 129 to again. Please come to 129, my lord. B at page 143. 152.
Yes.
Notwithstanding anything contained in this act, therefore it also starts with a non-obstante clause. No election to any panchayat shall be called in question except by an election petition presented within 60 days from the date of declaration of the election result to the tribunal constituted under section 127. So, my lord, this section 129, although subsection 1, also starts with a non-obstante clause. Notwithstanding anything contained in the act, in case an election of panchayat is to be called question, then it will be by way of an election petition, and under 127 election tribunal has been prescribed. Now, my lord will kindly come to section 111.
Yes.
Have your lordship's kind attention to section 111, subsection 2, clause C.
Yes.
Now, so read, it will read like this, my lord. No person shall be elected or co-opted and remain as a president, vice president, or a member of Jilla Parishad, Anchalik Panchayat or Gaon Panchayat, C, who has not passed HSSLC or equivalent examination under any council or board recognized by the state or central government as the case may be, for the post of Jilla Parishad and Anchalik Panchayat member. Here we are concerned with post of Anchalik Panchayat member. Now, my lord, will kindly find very interesting thing in this rule act, my lord. Now, the procedure is prescribed in Rule 62. Now, it could be on account of double marriage, my lord, multiple marriage. It could be on account of other disqualification also. Now, if your lordships kindly comes to Rule 62. Most importantly, my lord, Rule 62 subsection rule sub-rule A starts with the word subject to the provisions of this act. So that makes the provision very clear. Conditions and procedure of disqualification under subsection 2 of section 111 of the Act. Subject to the provisions of this Act, at the time of filing nomination, candidate shall be furnished affidavit that she has not more than 2 living children from a single or multiple partner. Now, this is regarding, my lord, having more children. Now, my lord will kindly come to sub-rule 2. Subject to the provisions of the Act, at the time of filing of nomination, candidates shall furnish affidavit regarding the required educational qualification along with true copy of such certificate, and also should produce the original certificate before the concerned authorized officer, failing which concerned candidate shall be disqualified. Now, my lord, subsection 2 stops there. Subsection 2 does not provide any provision. If a nomination is filed by a person who is disqualified, then what will happen? But in respect of having multiple children, it has been provided. Then kindly come to C, my lord. Now, 3. 3 is regarding, my lord, availability of functional sanitary toilet. C, 3. Then, my lord, C of 3 provides how the complaint will be entertained, how the issue will be decided. Similarly, my lord, if your lordship should kindly come to sub-rule 4, it says, subject to the provisions of the Act, at the time of filing nomination, the candidate shall furnish affidavit regarding their age at the time of their marriage, failing which the concerned candidate shall be disqualified. Supposing this requirement is not complied with, then what will happen? Kindly come to see. Gaon Panchayat Secretary, on receipt of information of such underage or minor marriage in respect of president, vice president, or member, shall inform the matter to the concerned block development officer. Oh, so, my lord, what I'm trying to submit is, in case of having qualification other than what is prescribed, no, my lord, remedy has been provided in this rule. So, meaning therefore, in case a person is not qualified and yet he files his nomination, or by whatever reasons, my lord, he is elected, then only way to challenge is to, my lord, by way of an election petition, because it can be construed to be a case of improper acceptance of nomination. So therefore, my lord, in a situation where the legislature intended that some power is to be given to the deputy commissioner, it has been expressly provided. For example, in case of, my lord, having more children, multiple marriages, not having, my lord, sanitary latrine and all, it has been provided. But in case of Rule 66(2), it only prescribes the disqualification, but it does not give any power to the deputy commissioner or any authority to adjudicate on that. Therefore, the natural corollary is, my lord, it is remedies only by way of, my lord, an election petition under 129B, and the forum is under 127. Now, my lord, recently a Supreme Court judgment has been delivered on this point, my lord. 2026 SCC online SC 136. Now, if a lordship should kindly come to paragraph 12, my lord.
Para
12. In view of the foregoing discussion, we summarize our conclusions as under. By virtue of the express constitutional embargo contained in Article 243(o) of the Constitution of India, the High Court is precluded from exercising jurisdiction under Article 226 of the Constitution, where a law enacted by the state legislature provides for the remedy of an election petition to redress the grievances arising during the course of an election. The election process cannot be lightly interdicted or stalled at the behest of an individual grievance. The right to contest or question an election being statutory in nature must be strictly construed and exercised in accordance with statute governing the field. The High Court must therefore eschew the grant of liberal interim reliefs in favor of individuals and instead remain mindful of the overreaching public interest in ensuring the smooth and uninterrupted conduct of election across the state. In respect of individual grievances, the ultimate and exclusive remedy lies by of an election petition. Given the non-obstante nature of Article 243(o) of the Constitution, its mandate is required to be adhered to in both letter and spirit, where statute provides a complete and efficacious mechanism for redressal, the extraordinary jurisdiction of the exercise of jurisdiction under Article 226 of the Constitution would defeat the very object for which Article 243O was enacted as a non-obstantive provision. So, my lord, these are clear. And recently, my lord, a bunch of petitions has been disposed of by this honorable court, my lord, where a similar view has been taken. My lord, I am handing over the copy, my lord. Para 81. Now, if your lordship should kindly come to para 60 of this judgment, my lord, where a coordinate bench of this honorable court, my lord, refers to 243O. Of course, that Supreme Court judgment possibly it was not laid before the honorable bench. Therefore, it could not be taken note of. Article 243O of the Constitution as a whole starts with a non-obstantive clause that is, notwithstanding anything in this Constitution in terms with clause B of the Article 243O, no election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as is provided for by or under any law made by the legislature of the state. The law made by the legislature of a state in the case would be the Act of 1994. At this stage, it is also apposite to observe that section 141 of the Act.
You're reading which paragraph?
Para 60, my lord.
160.
60.
Yes, please.
Article 243O of the Constitution of India as a whole starts with a non-obstantive clause. That is, notwithstanding anything in this Constitution and in terms of clause B of Article 243O, no election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as it may provide for by under or any law made by the legislature of a state. The law made by the legislature of a state in the instant case would be Act of 1994. At this stage, it is also apposite to observe that section 141 of Act of 1994 empowers the state government to make rules. In its exercise of power under subsection 1 of 141 of the said Act, that the rules of 1995 were made. Rules of 95 deal inter alia with the limitation of panchayat constituencies as well as election to panchayats, including election of president, vice president, or at any level of the panchayat. Then my lord will kindly come to paragraph 66.
Yes.
It is the opinion of this court that insofar as Article 243 of the Constitution of India is concerned, the same principles should apply. In other words, election to a panchayat can only be called in question by an election petition, taking into account section 129 of the Act of 1994. When such election can be called in question by presenting an election petition to the election tribunal constituted under section 127 of the Act of 1994. The above opinion of the court finds support from the judgment of the Supreme Court in DMK versus so-and-so and the Goa's case below. Eventually, my lord, at page number, para 75.
Yes.
In the instant case, even assuming that the petitioner had incurred disqualification on account of having married below the legal age as provided under Prohibition of Child Marriage Act, the said qualification was not taken into account while scrutinizing the nomination paper of the petitioner by the officer authorized, and consequently the petitioner contested the election and was elected as a member of the concerned Gram Panchayat. Under such circumstances, the case against the petitioner at best would be a case of improper acceptance of her nomination paper. Improper acceptance of a nomination is a ground for declaring the election void, and same has to be challenged by an election petition presented to the election tribunal within 60 days from the date of the result of the election. The authority under Article 243 F2 of the Constitution, as well as section 1111H of the Act, cannot usurp the jurisdiction of the election tribunal to decide the question of disqualification which the candidate incurred at the time of the election, at the time of submission of the nomination paper. The jurisdiction of the authority under Article 243F2 of the Constitution, as well as Section 111(1)(h) of the Act of 1994, would be only in respect to disqualification which occurred subsequent to the election. And eventually at paragraph 81, in the instant writ petition therefore stands disposed of with the following observations and direction. Impugn order which was passed by the Deputy Commissioner is set aside and quashed. All consequential action based upon the impugn order dated 9/12/25 is also set aside. There shall be no order as to cost. Now, my lord, now I'll trouble your lordships once again with the rules, my lord. Well, my submission would be slightly different from the view taken by the coordinate bench, my lord. Now, if a member of either of the panchayat, my lord, incurs a disqualification after being elected to the office, then, my lord, in the situation visualized by the act, the question may arise. But as regards the disqualification prescribed by Rule 62(2), my lord, no remedy has been provided. Therefore, its only way is to file an election petition, as I have submitted earlier also, my lord.
Mr. Chaudhary, your case may be viewed in a slightly different perspective because your disqualification is only with regard to a qualification which is otherwise not a criminal offense.
Not a criminal.
Other than criminal offense.
Yes.
And therefore, the Act itself has rules itself.
Provides
Rules have itself procedure.
Yes.
But I was just thinking, where will subsection C go?
Exactly.
No, if the coordinate bench.
But I am trying to submit for also kind consideration.
No, C not qua your instance.
Yes.
C is on a particular instance of underage or minor marriage.
Yes.
There is a remedy which has been provided by the rules. Now, for those, is it required to go to the election tribunal?
My humble submission is no.
Perhaps.
But that's why at qualification, which goes to the root of the matter, I could not have become, is a different. But if I have incurred the qualification after becoming a member, then also no election petition. And another thing is, for election petition, there is a procedure prescribed. In some of the judgment, honorable, but I'm telling the view of the Supreme Court.
Yes.
I have come across a judgment, my lords, where election petition was not filed, but that was also a case arising out of a criminal case. What had happened, my lord, just on the eve of, I've read one judgment, I think that was the state of Madras, not even, my lord, before the Reorganization Act. A man was, my lord, convicted for 7 years. But immediately in 52, my lord, while he completed less than 5 years, he was released. So he wanted to contest the election. He filed application before the Election Commission of India, but the reply from the Election Commission of India did not come. In the meantime, my lord, because he was released, he filed his nomination, he became a member of the Legislative Assembly. After he became a member of the Legislative, elected as a member of the Assembly, my lord, Election Commission refused the permission. Then the matter was brought to the notice of the, my lord, Speaker. Then in terms of, my lord, Article 192, my lord, the Speaker is required to refer the matter to Governor. It was done. Then the Governor again referred to Election Commission. Election Commission said that this is what already we have said it cannot be. Therefore, my lord, in that situation, a writ petition was entertained, and it was examined. That's a different. Other than that, I don't find any other judgment. There, the view of the Supreme Court was, my lord, in certain matters when the limitation for filing election petition is 45 days. Beyond that, if a persistent wrong survives, then what would be the position? Otherwise, my lord, by and large, the situation is different. It is always a simple case, my lord.
But even to 329B,
Yeah.
which lays a bar, that is only to ensure that there is no interruption in the elections.
Exactly.
It's, by the way, it also laid down that you can challenge an election petition. You cannot come before any court when the election has begun, but will that make a complete bar of entertaining a writ petition in all cases?
No, not in all cases.
Not in-
I'm
not
going to
in-
say in all cases.
That is what.
Especially in the case of the case which I am projecting, my lord, where the rule is silent. It provides, for example, please come to pay rule 62(1) for a moment, my lord.
Yes.
Rule 62(1), it speaks of the state government or concerned district authority shall remove any president, vice president, so and so, if he or she is having two or more than two children from a single multiple marriage. In this situation, I would humbly submit, my lord, here the election petition may not be the only remedy. There may not be a bar, but he can also approach, because the procedure is prescribed. How the Gram Panchayat secretary on receipt of the information, how will process the complaint.
Saka Venkata.
Saka Venkata. No, Saka Venkata. Why did you go say Saka Venkata? Conviction, Saka Venkata.
But this is with regard to 62(1) is regard to having two or more living children.
Yes. Now, please come to 2, my lord, regarding educational qualification. Here, my lord, nothing has been said. So it has to be related as an improper rejection of, under the scheme of the act and the rules.
Even for functional sanitary toilet
It is there.
in the residence, there is a mechanism how the information can be passed on to the authorities.
How that dispute can be gone into. Then subsection 4, my lord,
Age, same.
nomination the candidate
Age.
is affidavit regarding age. Here also, the my lord, there is a provision. But in case of qualification, there is none. Therefore, my lord, the legislative intent is very clear that in such a situation, only remedy is election petition. My lord, there are other aspects in this case. Who is the petitioner? We don't know, my lord, because his name is something, in his educational qualification is something. If your lordship gives a quietus to this matter on this point, I am not going to raise all those points. Apparently, my lord, the writ petitioner is an imposter. Is projecting himself to be X, but according to educational certificate is somebody else. And he has suppressed those facts. The matter can also be viewed from another perspective. The other disqualifications one may acquire afterward also, my lord, regarding more children. But regarding educational qualification, either you have a deepening or you don't have. So that is why, my lord, the rule-making authority or the legislature never intended to give any power to the deputy commissioner to adjudicate in these matters. Because it does not, the occasion doesn't arise.
You are an Anchalik Panchayat.
Anchalik Panchayat.
So you are required to be HSLC, HSS, higher secondary. For Gaon Panchayat, this is HSLC.
The petitioner would like to say that I do not have HSLC.
Disqualification. What is the expression used in 111?
Yes,
No person shall be or elected or co-opted or remain is also there. Remain is also. It may be a disqualification which you acquire
because my lord, no, my lord. Yes, if I acquire a disqualification.
even after. Yes,
Then
then also. Remain.
Yes.
Okay.
Now, my lord, that remain will not be applicable to me because either I have it or I don't
Do
have
not
it.
have it.
Yes. And most importantly, my lord.
And all those,
Huh.
the educational qualification, having more than 2 living children, and the aspect of child marriage are all parts of disqualification.
Disqualification.
And 62,
Huh.
except 62(2),
Huh.
the others have also laid down a procedure how you to.
Absolutely.
But 62(2)
Doesn't lay down any
the
procedure. Therefore, the intention
so
is.
you would contend that your contention would be fortified because of non-availability or the intent of the legislation not to prescribe any procedure for this particular.
This class of disqualification.
So this Ayesha Khatun, don't you think it should be restricted, confined to only those?
I was thinking, to be honest.
So what about the other C, then for more than 2 children, C and the other one?
There, I think, my lord, the legislative intent is clear.
It will be overreaching the legislative intent,
Yes.
perhaps.
Yes.
I've just had a cursory glance.
And most importantly, my lord, Rule 62(1)(a) starts with the word subject to.
We've seen that.
Yes, that's very important.
We've seen that.
Yes.
It's non-obstante is in the act and rules is subject to.
Yes, subject. So it has got a lot of significance.
May it please, Malaj.
Yes.
Malaj, before I start addressing on the issue of maintainability, Malaj, I may just point out that Malaj 127 prescribes a limitation of 60 days for filing an election petition. Now, my lord would imagine a scenario where a person, by way of fraudulent means, gets elected, and it comes to light later that that person, by way of fraudulent means, have been elected, and he suffers a disqualification. Will the court be remediless or the person be remediless? One more aspect, my lords. An election petition can only be filed by a contesting candidate. And if my lord goes by the scheme of 111, which is disqualification,
that is not confined to a contesting candidate.
That is not confined to a contesting candidate.
But you are a contesting candidate.
I am a contesting candidate, but my lords, an election petition can only be filed by a contesting candidate.
Yes.
Now, my lords, before I address my lords on the maintainability, I may just point out, my lords, what is my case in brief, my lords. My lords, I am a elected member of Fekamari Ancholik Panchayat. So is the
you are the petitioner.
Yes, I'm the petitioner.
Okay.
And so is the respondent number 7. So is the respondent number 7. Now,
you are members of
number 2 Fekamari Ancholik Panchayat. Number 2 Fekamari Ancholik Panchayat.
Okay.
Now, pursuant to his election, he was elected to the post of president, which my lord is aware is an indirect election. Direct election, the membership; indirect election, the president of the Ancholik Panchayat. Thereafter, it came to light, my lords, from RTI replies that the certificates furnished by him, which has been issued by the
no, those we remember.
That is fake.
Those were at the FSI consideration of.
Apparently, my lords.
Now on the maintainability,
when I address on the merits, my lords, apparently it will appear, my lords, that he has forged and fake documents, my lords. Now, on the ground of maintainability, my lords, my lord will first take up the constitutional scheme. My learned senior friend has referred to 243O. I won't trouble my lords again with 243O.
Yes.
Lord, may kindly take up 243F for a moment.
Yes.
And one more aspect, my lords. I have also prayed for a writ of quo warranto, my lords. In the writ petition, I have also prayed for a writ of quo warranto. And since I prayed for quo warranto, the judgment rendered by Aisha Khatun may not be a barrier for my prayer, my lords. Quo warranto has also been prayed for. Now, if my lord comes to 243O, 243F, I'm so sorry, my lords. May I read, my lords?
Yes.
243F. A person shall be disqualified for being chosen as and for being a member of a panchayat. A, we are not concerned with, my lords. B, if he is so disqualified by or under any law made by the legislature of the state. 2, if any question arises as to whether a member of panchayat has become subject to any of the disqualification mentioned in clause 1, the question shall be referred to for the decision of such authority and in such manner as the legislature of a state may by law provide. Now, if my lord reads both the articles, my lords, 243O and 243F, my lords, it would appear, my lords, that 243O envisages of a situation where the election is challenged, my lords. And 243F refers to a disqualification, my lords. They both operate in two different realms with the deepest respect, my lords. Now, if my lord comes to the Panchayat Act for a moment, my lords, kindly.
So there cannot be an allegation, election petition with the allegation of disqualification.
Yes, there
There
can
can be.
Yes, because my lords, that they both operate in two different realms. Now, like I agree to the submission made by my learned senior friend. There may be cases, my lords, by virtue of 45Z of the rules, it says if something is not provided, the laws, the ROP 51 will be applicable. So improper rejection, there may be a lot of grounds, my lords. In such cases, a person can always, within 60 days, if he's a contesting candidate, he can always file an election petition. But, my lords, giving it a meaning that only an election petition can be filed and the procedure prescribed in 111 and 62 cannot be followed would render the entire sections OTOs, my lords. They operate in two different. If my lord comes to 111 for a moment, my lords, kindly.
Yes.
Hundred and 11, my lord, it starts with both 111(1), 111(2). No person shall be elected or co-opted and remain.
Yes.
And remain. My lord would kindly note that.
Yes.
Now, my lord, if my lord comes to 111H for a moment, 111(1)H. (111)(1)H.
Yes.
If any question arises as to whether a member of a panchayat body at any level has become subject to any disqualification under this section, the question shall be referred for the decision of such authority in such manner as the government may by law provide. Now, 62(2), my lords, it says that if he has provided wrong, if he is not past HSLC,
okay,
he'll be.
Yes.
Yes, but that is also true, my lords, that the exact procedure may not be provided, and that
as may by law provide.
As may by law
so
provide.
the rule-making powers have been conferred on the government.
Yes.
They have framed the rules.
Right.
Rules take care of 62(1), 62(3),
right.
62(4).
Yes.
By giving a mechanism. Mechanism is almost parameteria.
Parameteria,
but
right.
two, it's silent.
Yes. At best, my lord, with regard to this submission,
yes,
62(2) says, my lord, subject to the provisions of the Act, the time of filing nomination, candidates shall furnish affidavit regarding their educational qualification along with true copy so and so, or failing which concerned candidates shall be disqualified.
Yes.
At best, my lords, it is a case of cases omissus, my lords. That is my submission with regard to. I don't have judgments on that point, but it is my submission. It is a case of cases omissus, my lords. Now, my lords, coming to the point of that Aisha Khatun and election petition, my lords. My lords would see, my lords, that judgment perhaps was passed without considering the law laid down by this Honorable High Court, my lords. And in my humble submission, my lord.
No, we have not read Aisha Khatun in detail, but prima facie view that it may not be applicable to all cases of
All
disqualification.
cases and my lords.
Especially a disqualification of the present nature.
Present nature.
What
present
decision we
nature.
take is a different matter.
Yes, yes. And my lords,
Pertaining to the facts of this case.
yes.
But holding that only election petition will be applicable, that will be making redundant
Right.
62.
Right, exactly. It will make it OTOs, man. Well, subject to.
But so for 62.2, we still have a,
Yes,
we have
yes,
to
yes.
ponder what
Yes,
is
yes.
it.
So that, my lord, in my this writ petition, my lords, that issue is taken care of because I have also prayed for a issuance of a writ of quo warranto.
Quo warranto by whom?
Quo warranto by.
You are not a general public. You are a contesting candidate.
No, for quo warranto, I'll satisfy my
Now,
lord.
quo warranto comes at what level? If you say that he is not qualified to hold the post.
Yes, yes.
He went through a scrutiny process of his testimonials being verified. He overcame it, and then now he is saying that there are some fraudulent.
Yes.
This can be matters of your grounds of your election petition.
Yes.
45 days, this limitation period.
60 days.
We can take care of that.
In 60 days, my lord,
We can take care of that.
my lord, this quo warranto, I'm equipped with a judgment of the Honorable Supreme Court.
Yes.
Where, my lords, under similar, my lord knows, my lords, this panchayat.
See, Mr. Mahanta,
my lord.
quo warranto makes your position slightly. We are not going with the strict requirement of locus in a quo warranto
Yes,
case.
exactly.
At this, we'll apply that principle when we see that you do not have that much of locus to challenge. Now you are fully equipped. You
Yes.
are having a locus to challenge. You are none other but the contesting candidate.
Yes, yes.
For you, why is the requirement to
My lords, in that case, my lord,
pray for quo warranto?
my lords, this Aisha Khatun judgment, well, if I may say, well, I may not be correct, I'll point out the judgment. It is per incurium, my lords, because this honorable.
Mr. Mahanta, you need not elaborate because perhaps for this case at least, we may not agree.
I'm pressing the judgment. for this case.
Because the division bench has held, my lords, that election petitions in a matter.
Please
pertaining
place
to-
that.
Yes, my lord, may kindly take up first the single bench, my lords.
Now place the DB.
Well, single bench, I'll just place one paragraph. my lord. That would make the more
Okay,
precise. my lord.
is it reported?
Yes, yes, reported. 2019, my lord, by Honorable Justice Chaudhary, Manish Chaudhary, Motive Roman. That I do, WPC 7705,
Reported, not reported.
2019.
2019.
Supreme Court. This exact
You could-
question cropped up, my lord.
Mr. Mahanta, you can just give the first page and the page having the relevant. Otherwise you can check. No need of wasting pages.
My lord.
For later reference. I'm
Yes,
just-
yes. My lord may directly come.
Petitioner, paragraph.
Paragraph 3 first. I'll just 3-4 paragraphs, my lord. Paragraph 3, I'll read it, my lord. The common issues involved are relatable to the insertion of the subclause section 2 of section 111 of the Assam Panchayat Act, inserted by the Panchayat, more particularly so and so in subsection 2 of section 111, insertion of the new rule of 62 in the Assam Panchayat Act constitution rules by the Assam Panchayat Constitution Amendment, and C, the judgment and order passed by the division bench of the writ petition, WPC number so and so, and the resultant effect therefrom. Now, my lords, the submission of the petitioners, if my lord directly comes to paragraph 5 for a moment. Paragraph 5, my lord.
Five.
5, my lord.
Yes, please.
Yes. Dr. Ahmed, learned counsel for the petitioner in WPC so and so, without disputing the facts therein, has submitted by referring to Article 243F of the Constitution of India and Section 127 and 129 of the Panchayat Act, that the provisions in Section 111(2)(a) of the Panchayat Act and the rule of the Panchayat rules have given rise to a dispute, and because of the dispute, the petitioner has been sought to be removed from the post of president of number 72 Bandorkona Gaon Panchayat with the aid of those provisions. In his submission, the petitioner can only be removed from the post of president of the Gaon Panchayat concerned by way of an election petition presented
The
for.
submission is per incurium the statute. 10 is or 10 or 11 is there for Gaon Panchayat president.
Yes, no, I didn't get.
Section 10
No, the Gaon.
is Gaon Panchayat.
Yes, president of Gaon Panchayat concerned by way of an election petition presented by the election.
That I think is the wrong submission. 11. Any dispute relating to the validity of the.
No, but it was, the judgment was dealing with 111, my lords,
No, this was with regard to Gau Panchayat. Gau Panchayat section 11 is there.
Yes.
Any dispute relating to the validity of election of the president and the vice president of Gau Panchayat.
My lord,
understand
I'll
to
just
decide by
check,
this.
my lord, give me a moment.
I think there's a misconstrued submission, perhaps.
Yes, my lord, but I'll read, my lord, but.
There's a specific provision in 11. So far as Gau Panchayat president is concerned, or vice president, it's the deputy commissioner who will decide.
Yes.
There's no requirement for to go to.
No, but that was not held by the.
No, that was, I am only with regard to the submissions.
Yes.
Recorded.
So, my lord, would next come to, no, the submission was that there has to be an election petition, my lord. Now, findings, submission of the government, my lord, just for a moment.
You come to the findings.
Findings.
Mr. Mahanta, why are you making it so late? Come to the findings.
Findings, I'll come to the findings.
We do not have that much of luxury.
Yes, my lord, sorry.
And come to
Paragraph
the-
17, my lord.
17.
Yes. With regard to the contention of Dr. Ahmed that a member either Gau Panchayat or the Anchalik Panchayat or the Jila Panchayat who purportedly incurs, here, my lord, Anchalik and Jila is also there, my lord, who purportedly incurs the disqualification under 111.
Does not deserve acceptance.
111 as
Does not
amended.
deserve acceptance. Last line.
Yes, and the line here, the main paragraph is, my lord, paragraph 25.
No, please read the last line in para 17. That will perhaps fortify your case. Does not deserve acceptance. Those have been rejected.
No, my lord, it has been held further, my lord.
Yes.
Would see kindly. My lord, paragraph 20, my lord.
20.
Yes.
Yes.
As per the provisions of section 127 of the Panchayat Act, the government shall constitute Panchayat election tribunals as may be on the recommendation of the High Court to dispose of all direct election petitions challenging elections under the Panchayat Act. The jurisdiction, powers and functions and the headquarters of the tribunal.
Mr. Mahanta, come to the issue. These are all.
My lord, here it
we
was.
have discussed and deliberated thousands of times. Please do not waste our time. Come to the question.
My lord,
which part?
Well, these paragraphs are important.
What important? Why are you required to read? What is a statutory only reproduction? What is section 10? What is 127? Are you required to read now?
No, it is.
Come to the issue. Please address the issue. Not required. You should know how to argue. Only because you are prepared, you will say everything. That is not required. You be with the court. We have understood your case.
My lord, would read kindly 25 and 26 from 2 paragraphs.
25. Yes, please read.
The other question raised is that a member of the Panchayati Raj institution who has purportedly incurred the disqualification under 111(2)(a) of the Panchayat can only be removed by an election petition presented before the election tribunal. In this connection, a reference can be made to the notification dated so and so issued by the Panchayat Rural Development Government of Assam on 30/9/2000. By the notification, the Government of Assam, in exercise of its powers conferred under Article 127 of the Panchayat, it should be section 127 of the Panchayat Act 1994 as amended, and on recommendation of the High Court had constituted 21 numbers of Panchayat election tribunals with the district judges with their respective territorial jurisdiction to dispose of all the direct election petitions challenging the election under the Panchayat Act. The jurisdiction of the election tribunal have been specified as under. This is important, my lord would kindly take note. Jurisdiction. The Panchayat election tribunal shall have jurisdiction to entertain and dispose of election petition filed before it by any contesting candidate in respect of validity and propriety of the elections. Next paragraph, my lord. A reading of the jurisdiction clause in this said notification makes it apparent that the Panchayat election tribunals shall have jurisdiction only to entertain and dispose election petitions filed by it by any contesting candidate in respect of validity and propriety of the election. It is a trite law that the tribunal assumes jurisdiction. Lordship may skip all that, my lords. In other words, the jurisdiction sine qua non, and my lords, (29), my lords. After referring to the notification, 29 is the important paragraph, my lord. Section 127 of the Panchayat Act gives the power of the government to constitute Panchayat election tribunals on the recommendation of the High Court to dispose of all direct election petitions challenging elections under the Panchayat Act, and it has also given the power to the government to decide about the jurisdiction in consultation of the High Court to decide about the jurisdiction, power and functions of the Panchayat Election Tribunal so constituted. The notification dated so and so has conferred jurisdiction upon the Panchayat Election Tribunal only to the extent to entertain and dispose election petitions filed before it by any contesting candidate in respect of the validity and propriety of the election, as the jurisdiction to decide, my lord would note that, jurisdiction to decide about disqualification of a member of a panchayat, be it Gaon Panchayat or Anchalik Panchayat or Zila Panchayat, incurred under section 111(2) of the Panchayat Act and the Rule 62 of the Panchayat Rules, has not been conferred upon the Panchayat Election Tribunal. The contention advanced by Dr. Ahmed in this regard is found bereft of any substance, and accordingly the same is not accepted. Lordship may skip 3-4 lines. It will be the procedure which is prescribed in Rule 62 of the Panchayat Rule, which will govern the matter of removal of a member, Panchayati institution, disqualification under section 111, 2A of the Panchayat, read with 62(1)B of the Panchayat Rules. Now, this matter went to the Supreme Court. My lord, may kindly peruse this, the division bench. Okay. There is division bench, the motive went to division bench. Read appeal number, yes. My lord, here I won't trouble my lord. My lord may directly take up paragraph 7.
Division bench.
Division bench.
22 SCC online Gauhati 2469. Paragraph?
Paragraph 7, I'll read it out.
7.
7. Just one paragraph. 7 and 8. The learned counsel for the appellant writ petitioner would then argue that one can only be removed from the post of president of a Gaon Panchayat by way of an election petition filed before the election tribunal constituted under section 127 of the Assam Panchayat Act, and in case of a disqualification, it can be challenged before the election tribunal by a candidate and it cannot be done by a bureaucrat. This submission of the learned counsel of the appellant writ petitioner is entirely misconceived and as such did not find favor with the learned single judge. Under the Assam Panchayat Act, an election petition can be filed before the election tribunal constituted under section 127, wherein a challenge to an election can be made on grounds which have been given under section 127A to 127R. This is an entirely different matter. This relates to disqualification attached to the office of the president, vice president or member, as the case might be, and in the event of their disqualification have to be removed. The provision of such disqualification and removal, as already stated, has been put to challenge and the virus has been upheld. The appellant has not shown before the court any procedural violation of 111(2)A of the Assam Panchayat Act. We are therefore totally in agreement with the learned single judge. Rightly or wrongly, my lords, as on date, there is a division bench judgment which clearly rejects the contention that in a case of disqualification, there has to be an election petition. Now, my lords, Lordship may kindly peruse another judgment, my lord. I won't take much time. My lord, the election tribunal notification is also there, my lord, where the jurisdiction has been
39-2000.
Yes, yes.
We have seen that. 39-2000,
Yes,
isn't it? We can play, we can have it for
yes. So drawing an analogy from the notification, matters of disqualification, the jurisdiction has not been vested on the election tribunal. Now, my lord may kindly take up another judgment, my lord. Well, I'll try to be as precise as possible. This is 1994, 4 SCC 526. Sorry. It will hold up K. Venkatachalam versus Swami Kali. It will refer to
Just a minute, please.
Yes. Yes.
Mr. Mohanto,
Yes, my lord.
Mr. Chaudhary also, I was just trying to understand what the Honorable Division Division Bench in the last part of the judgment has said that.
Lord, before that, may I
No,
take your-
just I'll seek a clarification. We're not here to examine the division bench judgment, but let us understand, let us deliberate and discuss. Paragraph
8, my lord.
8, not 8, 7, last paragraph, last line,
Sentence.
last sentence.
Under the Assam Panchayat Act, an election petition can be filed before election tribunal constituted under so and so, wherein a challenge to an election can be made on the grounds which have been given under section 127A to 127R.
Can we look at 127A to 127R?
Election offences.
127
A pura R.
A to R.
A to R. These are all offences for which cognizance can be taken in a by a criminal court.
Yes.
But can it be restricted, the election petition be restricted only to these offences? In fact, these offences may not be connected at all with an election petition.
In fact, the reasoning of the single judges, my lords, that's different from the division bench.
No, but Mr. Mohanto, just see 127A. This can also be part, but can it be restricted to this? These were made part of the statute.
This is done, my lord. Then the substantive provision
Will,
becomes obvious.
Otius. And this was inserted later in 1999. We would like to see the objects and reasons.
Yes, it came to be inserted in 99.
These are made punishable offense, and the penalty has also been prescribed. Imprisonment for a term which may extend to 3 years, bailable, non-cognizable.
Don't think, Milwas, it was intended to be a part of the election petition.
And the very aspect that these have been inserted at a subsequent stage will be contrary to what, with all the greatest of respect, you cannot make certain things which only because of those fulfillment an election petition will be maintainable.
That was not held by the single judge. This
But DB, maybe it's a cursory kind of an observation.
Yes, yes.
That it will be restricted only to 127A to R.
Single bench of one.
To put it in the words of my learned friend, it will be orbital.
Maps.
Okay.
I have
Yes.
placed another judgment.
That's why it is said, my lord, when we read a judgment, we should not read it like a statute.
Facts are important.
On facts, it is rendered. What is the context? Not merely because there is a sentence in a judgment, it should not be read like a statute. The meaning has to be called out in the attending.
I'm not referring to that at all, my lord. The single judge's judgment has been succinctly, my lord. It has dealt with these submissions made, my lord.
You're referring to Venkatachalam?
Venkatachalam. Now, my lord, Venkatachalam, my lord.
Yes.
My lords, that bar in interference, my lord is aware, my lord, Article 329B, which is for the legislature, my lord, member of parliament, is perimetered with 243O, exactly same, my lord. And my lords, 129B is also perimeter, section 129B. Now here, my lords, we're not dealing with a panchayat member, but we're dealing with a member of the legislative assembly, my lords.
The example which I gave, this is the case.
That my lord's senior friend's case has been referred. Now this is to show, my lords, that going by my learned senior friend's submission, that if the 60 days period expires and if a person is found to be disqualified, no, even a writ petition cannot be filed. My lord, this is for that, my lord, to show, my lord. First paragraph, my lord.
Which paragraph?
First paragraph, first 2 paragraphs. I'll read it very, my lord. The Division Bench of the High Court of Judicature at Madras by its judgment dated 23/4/1986 in the writ appeal declared that K. Venkatachalam, the appellant before us, was not qualified to sit as a member of the Legislative Assembly in Tamil Nadu as he did not possess the basic qualifications in clause C of 173 of the Constitution, read with section 5 of the Representations of People Act. The division bench held that the appellant was not an elector for Lalgudi Assembly constituency and therefore did not possess the necessary qualification to be chosen from that constituency. The High Court passed impugned judgment in exercise of jurisdiction under Article 226 of the Constitution. A single judge of the High Court had, however, earlier dismissed the writ petition challenging the election of the appellant on the ground that it was not maintainable under Article 226 of the Constitution in view of the bar contained in Clause B of Article 329, which is perimeter with 243O. General elections in the legislature, so we'll skip 4 lines. A year after the date of the elections, Venkatachalam, a petition under 226 of the Constitution was filed by Swamikan for declaration that Venkatachalam had not qualified to be a member of Tamil Nadu Legislative Assembly representing Lalgudi Assembly since he was not an elector in the elector roll of the Lalgudi Assembly for general elections in question. He also prayed alternatively for a writ of quo warranto directing Venkatachalam to show under what authority he was occupying the seat of Tamil Nadu. Legislative Assembly as a member of the so-and-so. Swamikan did not present any petition calling in question the election of the Venkatachalam under 81 of the Act. He alleged that Venkatachalam impersonated, here is a case of fraud, my lords, him on other person of the same name in the electoral roll of Lalgudi Assembly constituency and thus had sworn a false affidavit and that he was an elector in that constituency. It was alleged that the act of Venkatachalam was fraudulent and a criminal act which came to be known to Swamikan after he scrutinized the entire electoral roll of Lalgudi constituency. Now, my lords, would directly come to paragraph 20. 20, I'll sum it up, my lord. I won't read it out. It said a person cannot be left remediless, my lords. Just because the limitation period for filing a election petition has expired, a person who is otherwise disqualified cannot remain, my lords. A writ is maintainable. Now, my lords would come to para, just 3 paragraphs, my lords. Well, just give me a moment. Yes. Para 24. From this judgment, it is clear that the court held that Article 191, which lays down the same set of disqualification.
Para 24.
24.
Not 20.
24. 20, it says a person cannot be left remediless. I'm not reading the entire paragraph.
Okay. And 24, you're
24 minutes.
okay.
From this judgment, it is clear that this court held that Article 191, which lays down the same set of disqualification for election, as well as continuing as a member of so-and-so, Lordship may skip 24, Lordship may come directly to 25. In the present case, the appellant was not an elector in the electoral roll of Lalgudi Assembly constituency. He therefore could not be elected as a member from that constituency. How could a person who is not an elector from the constituency represent the constituency? He lacked the basic qualification under clause C of Article 173 of the Constitution, read with Section 5 of the Act, which mandated that a person to be elected from an assembly constituency has to be an elector of that constituency. The appellant in the present case is certainly disqualified for being a member of the Legislative Assembly of Tamil Nadu. His election, however, was not challenged by filing an election petition under Section 81 of the Act. The appellant knows he is disqualified, yet he sits and votes as a member of the Legislative Assembly. He is liable to penalty of 500 rupees in respect of each day to which he so sits or votes, and that penalty is recoverable as a debt due to the state. There has not been any adjudication under the Act, and there is no provision of the Constitution as to how the penalty so incurred by the appellant has to be recovered as a debt due to the state. The appellant is liable for penalty, nevertheless, as he knows he is not a qualified so-and-so, so-and-so. The question arises for consideration is, if in such circumstances, the High Court cannot exercise its jurisdiction under 226 of the Constitution of India, declaring the appellant is not qualified to be a member of Tamil Nadu Legislative Assembly from Lalgudi constituency. From the finding recorded by the High Court, it is clear that in his nomination form impersonated a person named so-and-so, taking advantage of the fact such person bears his first name. The appellant would even be criminally liable as if he filed his nomination on the affidavit impersonating him. If such circumstances he is allowed to continue and sit and vote in the assembly action, this would be a fraud on the Constitution. In view of the judgment so-and-so, Saka Venkata Rao, Namala, we are therefore of the view that the High Court rightly exercised the jurisdiction entertaining the writ petition under Article 226 of the Constitution of India. Similarly, my lords, in the instant case, my lords, the person apparently suffers from a disqualification. When Lordship hears me on merit, I can prove, my lord, from public documents that he has forged and he has misled the authorities. Now, my lord.
No, Mr. Mahanta, the immediate question which will come, in fact, which we are contemplating.
Yes.
Your allegation of he suffering a disqualification are based on certain evidence.
Yes.
Which obviously Mr. Chaudhary would be disputing.
It cannot be disputed.
No, that is your perception.
Yes.
You cannot stop him from disputing.
Because I'll say why, my lord, because those are certified.
First of all, let him establish whether
No,
right
no,
man
I have
is-
not yet
No, my lord.
started.
My learned friend is, I have not even uttered a single word. My lord, he is imposter. I have brought a record materials. Kindly see, my lord, who is he?
No,
He is Talukdar or Munaf.
This is just to hoodwink this court, my lord. It's not even material to the.
No, Mr.
I'll come when I
Mr.
come.
Mahanta,
Yes.
see, you will have some allegation. We are not even, do not even know what are the counter allegations which should be leveled by your senior colleague. But there would be
Let him
questions.
file a writ petition.
No, why should he file a writ
No,
petition?
for the alley, I'll come to that, my lord. It's apparently.
Why is he aggrieved? He's not aggrieved.
He's not aggrieved. He cannot raise such questions. It's
No,
not material to
he
the.
why will he file? He can raise a defense.
Yes. So, my lord,
Challenging your
when I come
Lucas,
to
why
the
not?
merits,
Just for that. But ultimately,
I'll try and satisfy.
how does the writ court
Yes.
determine questions of fact which are not only disputed but seriously disputed?
Yes.
You
For
can
that-
resolve
for that-
this. You can resolve this. You are not remedialist.
Yes.
You can resolve this by adducing evidence,
Yes.
and your
Evidence action. Yes.
your witnesses would be subject to cross-examination,
Right.
which you'd have all the amenities in a tribunal.
Right. In that regard,
The only predicament which you would suffer is the aspect of limitation.
yes.
We can take care of that.
With regard to the, my lords, allegations and counter allegations, when I come to the merits, my lords, there are certified copies of an authority which are public documents, my lord. As per the Evidence Act, there is a presumption. There's a
Mr.
presumption.
Mahanta, we are writ code.
Writ code, exactly.
It's not
When
a
I'll
civil
come-
code. How do we have the expertise?
Lordship may-
You give a document before us
yes.
without giving them to a cross-examine. How can it may be an authentic document?
Yes.
But it
No,
will not.
my
It
lord,
will not pass the
a
test of a cross-examination.
The report disbelief a document given by
It's
an
not-
authority, my lord.
it's not a question
Which is
of-
an authority.
My God,
I'm
Mahanta.
so sorry, my lord. I'm so sorry. I'll place.
You have to change your thinking.
My lord.
It's only a question of the ability to decide whether we are equipped with that expertise to decide. You may be 100% correct. It's an authentic document. Only because you say it's authentic, this court, being a writ court, cannot say it's authentic unless it goes by the process of a cross-examination.
So, my lord, in that case, my lord has to first peruse those documents. Only then.
No, even if we assume that those are correct, can we say that without giving them a chance? So these are having adverse consequence. Your entire case is dependent on those documents, which you say that those are forced documents.
No, I'm not praying for a mandamus from this court directing that he should be disqualified. I'm saying the deputy commissioner should.
Under
act
what
on my complaint.
provision?
Deputy commissioner.
Under what provision? 62(2) does not have a provision of the deputy commissioner. That is the problem.
Yes.
Had it been in a child marriage or underage marriage or more than two wives.
Venkatachalam's judgment solves
No,
it, my lord.
this particular disqualification on educational ground, that is not supported by any other consequential or procedural aspect. Unlike 62,
Yeah.
1, 3, 2 doesn't have. Why it's blank? Just address on that issue.
My lord.
See, 62(1), 2 or more children, there is a provision. 62(3),
Yes.
sanitary toilet, to the extent sanitary toilet, there is a provision. 62(4), child marriage provision. 62(2), education qualification, no provision. Why?
My lords, like I said, my lords, it may be a case of casus omissus, my lords. That lordship would give me
No,
some time. That has been raised today. I was not
how
aware.
can we presume? No, that's a legal point.
Yes,
It's
I
a
know.
statute.
Yes.
You cannot ignore what, cannot presume that it has been left out somehow.
Yes. I was not, my lords, I was not anticipating this argument, my lords.
No, in fact, this court also for the first time had realized that because these are say sanitary toilet not having, even for that procedure has been laid down.
Yes. And insofar.
And these are objective standards. You can go an inspection, no sanitary toilet, matter ends there. But still then.
Insofar as my lord's pointed query that those documents are disputed, and my lord, the ASS, the Assam Secondary Education Board, who has furnished those documents, is a party to the writ petition. They are a party. Now, if an affidavit comes from them saying no, it is forged, then this court would perhaps. And they're certified copies from an authority, my lord. It's not so. And there's another aspect to the matter.
Sir, Mahanta, certified copy is not the problem. The problem is the aspect of proof.
Yes.
The presumption under 62, perhaps.
Yes.
We'll have to raise in a civil court. This is a forum which is slightly different in a civil court. We go by mainly by the affidavit and the documents. Once a question comes, raising a single issue, it becomes disputed questions of fact.
I'll please try and persuade my lords by placing judgments, because I have come across judgments, my lords, where the evidence is crystal clear, my lords. The court would even. And there's one more aspect I
See, these are prerogative writs, Mr. Mohanto. Judgments will be precedents on those facts. These are all prerogative in nature. You make it an extraordinary case. But if it sense that we may not do justice on disputed questions of fact, we will not undertake that kind of an exercise.
My lord,
but we will not preclude you. We will have all the remedies.
Yes, my lord would see this. And one more aspect, if I may be allowed to point out, my lord. My lord has seen section 127, my lord.
Yes.
Election petition, a direct election can be challenged by an election petition, my lord. Now, even assuming, my lord, these judgment, Aisha Khatun's judgment would overrule the other coordinate bench judgment or the division bench judgment, my lord. Even in that case, my lord, I have prayed for setting aside his election as the president, which is
that we would have given. In fact, we have given an anxious thought. See, you have mentioned very correctly direct elections.
Yes.
Direct elections, and for the president, it's indirect election. But to become a president, you have to become a member first.
Yes.
You cannot challenge the president unless, because you are challenging the membership also.
Exactly.
Disqualification is mainly on the membership.
Exactly.
So that is a direct election.
Just assuming, my lord, the direct election I cannot challenge because there's a bar of election petition. In that case, the indirect election can be challenged, because indirect election, you may not file an election petition. His election as the president, he can still remain as a member, my lord.
That indirect election under what procedure? Where does the DC get the power?
The DC's power is in 111H, my lord, the authorities. 111H is clear, my lord.
No. You have to go to the procedure, how the DC information is passed on to the DC.
Yeah.
The district commissioner, he takes a decision.
111H states, my lord, if any question arises as to whether a member of Panchayat body at any level has become subject to any disqualification. Under this section, the question shall be referred for decision of such authority in such manner as the government may by law.
Exactly. That is there has to be a law which has to be made by the government. Rule making powers are there. 111, you cannot rehearse what is 62. 62, 1, 2, 3, 4. 1 is there, 3 is there, 4 is there. 2 is missing.
Who is clear, my lord, he should be disqualified, but who will disqualify and the procedure for
And if the law does not envisage a particular authority, and there is a provision under 127 giving such a dispute to be adjudicated by a...
yes.
So that...
With the deepest aspect, my lord, if such interpretation is given, my lord, then 111 2 and this 62 2 would also become rendered, my lord, negatory, my lord.
No,
because there has to be disqualification for a person who does not possess HSLC. What would happen to that, my lord?
He has,
in provision provides.
Mr. Mohanto, he has passed the scrutiny process.
Yes.
Now you still allege that those papers are not authentic. Those
Because
are
came to light later, that's what.
later. You
Yes.
came, you still, and you may be correct in contending, but he has to be given an adequate chance in an appropriate forum, where he gets the right to cross-examine.
Right, I am.
That is the only thing. Otherwise, on merits, you may have a very good case. Or let him complete. He will come.
So what my lord is pointing out that the petitioner may get a liberty to approach the
No,
forum.
that in worst case scenario, you will get that. Don't worry. But we have not negated your submission. We will consider.
My
We'll
lord.
consider.
My lord.
DB you have there given, but DB last sentence
Yes.
somehow you have to, if you do not agree with to say something. Can it be confined to only 127A to 127R?
But
As an officer of the
right.
court, you just
No, I don't.
maybe it was maybe it's a cursory kind of a remark while agreeing with the division single bench. And single bench went on a different trajectory, and division bench on a different.
The single bench held matters because that notification does not give jurisdiction to the tribunal to decide matters of disqualification.
To that extent, you are correct, but that extent, division bench has said nothing. Number one, and honorable single bench has not taken this particular thing which has been argued by Mr. Chaudhary. 62-2.
62-2. 62-2.
62-2.
Yes. In fact, that
Difficulty is
point of
only
time-
60. Difficulty is only 60. Even for just trivial matters like having a sanitary toilet.
Yes.
Procedure has been prescribed. The other matters are much serious. Having more than 2 children, having being involved with a child marriage, those are criminal offense. For that, but even for sanitary toilet. Okay, we'll consider. Yes, Mr.
5 this.
Yes.
Now, please come to that motive Romans case 4 lines, para 4.1.
Motive this
That
division bench.
single judge.
Okay.
Just 4 sentence, my lord.
Paragraph.
Paragraph 4.1. Third sentence.
Just a minute, please. 4.1.
Para 4.1.
Will judge.
What was the case which the learned single judge as well as division bench was dealing with, my lord? Because a judgment is an authority for what it actually decides. The third line, the petitioner herein participated in Panchayat election held in the month of December by submitting his nomination on 19/11/18, thereby offering his candidature for the post of president of 72 Bandorkona Gaon Panchayat. When the election results were declared, the petitioner was declared elected for the post of president of number 2 Bandorkona Gaon Panchayat. A certificate dated 15/12/18 to that effect was issued by the Deputy Commissioner Karimganj. At the time of filing his nomination, that is on 19/11/18, the petitioner had 2 living children. He was blessed with another child on 27/2/19. After 27/2/19, respondents number 5, 6, and 7 filed a complaint before the Secretary Bandorkona Gaon Panchayat to remove him from the post in view of the provisions of so and so. Well, how a judgment rendered in these facts is applicable in my case? Admittedly, the moment third child is born, you have incurred a disqualification. So in such a situation, there is no question of filing an election petition. How would one know that 1 year henceforth, somebody will have a child? So how, with all respect, my lord, how this is applicable here? It's a judgment rendered on the facts of this case. Now, my lord, my learned friend has referred
What are the expressions used for more than 2 children?
Yes.
Disqualification, triple
Yes,
one.
First come to 111.
Triple one.
F, my lord.
F, yes.
Has been during 4 years immediately. No. Kilo. 2, my lord. No person shall be elected or co-opted and remain as a president of so-and-so, 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 who has more than 2 living children from a single or multiple partners.
Who has?
And remain. And naturally, my lord, remain will come post the election. Therefore, in such a situation, to insist on an election petition is absolutely misconceived. So that could not have been. I don't think, my lord, there is a necessity to write. It's a wrong judgment of that.
They can be separate as well. my lord.
Provided that this provision shall not be applicable for in those who have more than 2 children prior to the. Okay. Oh, there is this, I think will clarify.
Ah,
One who had more than 2 children prior to the commencement of the S Act,
ah,
he is saved.
ah.
So, but one who will have more than 2 children after even after the
Yes,
elections.
then the disqualification comes in. Now, my lord, so this is the aspect. So therefore, my lord, perhaps, my lord, that judgment was rendered on the facts of that case may not have any relevance in deciding this case. Where we are concerned basically with interpretation of clause 2C.
Yes, interesting. Mr. Doctor, anything?
Yes,
else?
one more minute,
Yes,
one minute. My lord, my learned friend has referred to section 1111H.
Yes. H we have law.
My lord, 243F. My lord, it itself says, if the legislature provides in
Provides.
it has provided. In case of 2C, nothing has been provided. That's all.
No,
And
that we have already.
And that, my lord, Supreme Court judgment, there is an extreme case, my lord. That 94 SCC, my lord. That is an extreme case in the facts of that case. I don't think, then what meaning we give to the present judgment, which is directly on 243O, the one I have placed today. Therefore, my humble submission is, my lord, it's a fit case where he should have filed an election petition. And, my lord, for example, under the Motor Vehicles Act, now earlier, my lord, the limitation of filing a claim was 6 months. If you miss the bus, that's the legislative intent. That's why it is said, my lord, when the legislature, Parliament of the state legislature gives authority to the court to condone the delay, then only it can be. If the power to condone the delay is not given, the courts are helpless, my lord. That is the position in my humble submission.
I'll just add one point, my lord. My learned senior friend had referred to the Sandeep Bora matter, Supreme Court, my lord. Like my friend says, my judgment is the authority for what it decides. In that matter, my lord, there is no provision akin to 111. I'll just, my lordship may take note of that. Sandeep Bora's matter is pure election petition and no provision akin to section 111.
Yes, Mr. Doctor.
One to the judgment of Aisha Khatun, my lord. And after reading the provisions and Aisha Khatun judgment, my lord, I want to make submission, my lord. In case of, my lord, improper acceptance, my lord, the only remedy before the election tribunal, my lord. And in case of subsequent, my lord, after election, my lord, these rules are there, my lord, power empowering the district commissioner to interfere. Because, my lord, if lordship will see the rule 62, only those situations, my lord, the provisions of disqualification under 111, whose can be subsequently can be done, my lord, only because of those provisions, my lord, rules are there. If educational qualification, my lord, in case of nomination, it's improperly accepted, for that, there are no provision, because subsequently there is no scope for again, my lord, for that provision, my lord. But in case of, my lord, the more than 2 children, all child marriage, my lord, those are there, my lord, because those are maybe violated after the election, my lord. So this Aisha Khatun, my lord, in 75, my lord, paragraph, it's specifically stated, my lord, in case of, my lord, improper acceptance, my lord, only election tribunal. And if subsequently the section 111 will be triggered, my lord, there are provisions, my lord, empowering the district commissioner, my lord, giving power to exercise this section 111, my lord. So others point my senior colleague had already.
But for subsequent violation,
my lord,
subsequent violation can be related to only the disqualification relating to more than two children. Number one.
There are other provisions also there. Sanitary provisions also there. After election, if someone had removed sanitary provision, that those will come, my lord. Child marriage will be there, my lord.
Child marriage cannot be after.
Because he can be, spouse is also there, my lord. After election, if he marries, my lord, as minor girl, that will come. 62(4)(b). Spouse is there, my lord. Unmarried also can contest, my lord. After the election, if he marries a minor girl, then that section will come.
But Aisha Khatun does not envisage a situation where fraud has been played upon the authority. That has not been dealt with, my lord. In all cases, it can be subsequent. If there was initially a fraud has been played, my lord.
In fact, my lord, in
The
case
fraud
of
would vitiate everything.
anti-defection, district commissioner has power because prior to election, that cannot be come.
Yeah, anti-defection is taken care of by
Yes,
there's a
yes,
specific
yes.
45 or something.
Yes,
What was it?
in this case, judgment, my lord, it's an every provision has been justified, my lord. So my submission will be, my lord, this case is not maintainable as present for my lord. Therefore, that may be dismissed, my lord.
Disqualification. Okay, we'll consider. Okay. Third, Mohanto, so is the Panchayat, and K. Chodu, is Sana. We will consider. We'll resolve this.
I know. I'm ready.
Deeply obliged. Low.
Unless the prayer would. Timing, time. Huh? Unless they are material. Timing, yes. Motion.
My lord, in this case, as an unemployed youth, a particular plot of land was, my lord, allotted to the petitioner. This is a cooperative society, my lord. And the land was never handed over. Then, my lord, when we insisted on that the land should be handed over, then the plea was sought to be taken that as it is a village grazing ground, and therefore, when the government allotted the land, there was a provision that it should be de-reserved, then only it should be given. And it so happened, my lord, the de-reservation aspect was not gone into. Now, thereafter, my lord, it continued like that. We filed the writ petition when this instruction was placed. But after filing of the writ petition, what we find, my lord, as we all know nowadays, what happens, a particular MLA and a particular minister, my lord, had, my lord, taken possession of the land, and they have put on walls also, my lord. Now, if for de-reservation it cannot given to us, then it cannot be given to anybody else. That is the position, my lord. That is
Yes,
how
what
on
is
last
this?
occasion, this instruction was sought for, my lord, on 11/2/26.
You've got the instructions. What does it say? You can just spell it out. What does it say?
Where your lordship? Second page, your lordship. Regarding the VGR and allotment of the VGR and the PGR land, your lordship, re-reservation process, your lordship. The point number 4.1. Lordship, it is stated, Lordship, this instruction has been received today morning, your lordship. It is stated that under the relevant rule 95A of the rules under Assam Land and Revenue Regulation,
only in those cases where it involves. In this case of individuals where lease administrative mandate has been granted under some government notification to landless laborers, persons rehabilitated due to erosion of lands, members of the scheduled caste or tribe and the like. And in respect of institutions, only in respect of government institutions and other institutions of the public utility. The de-reservation proceedings followed by the allotment settlement in all such cases are placed before the competent authority in the government and.
No, that is okay. No, those are okay, madam. The reservation, you did not, they take a decision in their favor. But what about the allegation that this has been given to somebody, some political person?
Yes.
That instruction you have not got?
This.
Well, kindly see, my lord, overnight they are putting up a boundary wall, very powerful persons.
This point.
Let them file an affidavit, my lord. We'll reply.
This point, Your Lordship, today.
And my lord, if on the
Just a
ground
minute.
of de-reservation, it was not given to us. Now it has been de-reserved, give it to us. We are also educated, unemployed youth. We are
No, the
local boys.
instruction has not said de-reserved.
Yes.
Instruction has said that the
In
matter
an
was taken up.
appropriate case, it may be required.
No, the instruction said it has not been agreed to be de-reserved.
Also, Your Lordship, in the first point, also in the first page, Your Lordship, it is stated that.
But Mr. Chaudhary, where is your submission?
Yes,
It has
my
been
lord.
given to somebody.
No, my lord, this has happened after filing of the
This
writ
is
petition.
You file.
Oh, I mean,
Mr. Chaudhary,
No, we have filed it, my lord. We have filed it.
you file an additional
Yes,
affidavit.
yes. We have filed it.
We'll take it very seriously.
Yes, we have filed it, my lord.
Photographs and all,
Ah.
Your Lordship. This is.
Ah.
That the walls are.
Okay, we'll file an additional affidavit, my lord. Not in very clear terms.
You put it,
Yes,
the
yes.
allegation on record?
Yes, yes. We'll do that.
We'll seriously look into it.
Kindly give us 10 days time. my lord.
Because there is no other reason. We have been very strict on VGR land.
Yes, yes.
If we are being strict on VGR land, we want the government to be even stricter on VGR land. It cannot be on case to
In
case.
fact, on last occasion, when the matter was listed before another coordinate bench, same was the view of that honorable court also, my lord, saying if you can't give it to them, don't give it to others also. on that ground.
Cannot be.
Yes.
Not given
Even
the
the,
Lordship as per.
your responsibility is much more
If it is
than us.
not given, why the boundary wall?
Okay.
And that to construct RCC.
So, Your Lordship.
Herds,
the encroachment-
Herds Free Ken Chaudhary and Senate Council for the petitioner, as well as Miss Ann Bodler, Learned Standing Council, Revenue Department. Full stop. The Learned Senate Council for the petitioner has informed that while the aspect of de-reservation appears to have been rejected so far as allotment of the land to the petitioner is concerned, there are noticeable developments concerning the said plot of land that the same has been allotted to some political persons. Full stop.
This is an
Tara?
allegation, Your Lordship.
Huh?
It's an
Yeah,
allegation, Your
That is the what violated. On the other hand, Ms. Bodloy, the Learned Standing Council has placed before this court written instructions dated 16/3/2026, as per which, the aspect of re-reservation has not been accepted in view of the categorical direction of the Honorable Supreme Court in the case of Jakpal Singh versus State of Punjab. Full stop. Let the allegations presently leveled by the petitioner be put on an affidavit so as to give.
Lordship, if I may read the other points, Your Lordship, point number 4, if I may be allowed to read the other points. Point number 4, 2 and 3.
We are not passing a judgment, madam. Are we passing a judgment that you have done something? We are only giving you a scope.
Regarding the encroachment, Your Lordship.
Yes.
The status needs to be derived from the DC office and the circle office, Your Lordship. Because.
Let him file the affidavit. The appropriate person will respond to this. If you think you are not competent, the competent person will respond. Whoever is in the helm of affairs, they'll respond. Put on affidavits so as to enable the enable the respondents to file their response based upon which appropriate orders would be
My lord,
passed.
there was a status quo order passed on 11/2/26 that may be continued, my lord.
The
Status quo,
order of status quo
11/2/26, my lord.
passed earlier stands extended till the next date of
Deeply
listing.
applied. Deeply applied.
Lordship had fixed a date
We'll give it, how soon can you file the?
10 days, my lord.
10 days.
for filing the affidavit, but then regarding the overall status, your lordship, they have asked for some time because the ensuing elections.
Let them file the affidavit, we'll grant you reasonable time.
Yes, sir.
List on, today is 16th. We'll have it on, can we have it on 1st of April?
First, let it be 30th, my lord.
30th of
First,
March,
yes.
30th of March, by which time the affidavit, additional affidavit is required to be filed.
Deeply applied.
Pleasure.
Mr. Metal, Abdul Qadir, persist in yours.
Please, Lordship.
Yes.
Lordship may kindly come to page 21.
Who's for the other side? Who's there? Revenue Department or which
Lordship.
department?
Revenue.
Madam, who's there?
Lordship may kindly come to page 21. This is an allotment order passed in the name of the father of the petitioner in the year 1977, Lordship.
Yes.
77 allotment order. And
In name of father?
in the name of the father of the petitioner, Lordship.
Yes.
Lordship, and since then, they are living there by constructing dwelling house.
You are staying there?
Lordship, since 77. In the year 2004, one school named Bangabanga LP School. Bonnabanga is another place. This school was shifted to this village. This is village Gugudoba. This was shifted behind the house of the petitioner, Lordship. And that school was without ingress and egress, Lordship. But the showing social responsibility, the petitioner allowed the students and the staff to pass through the boundary of the petitioner, Lordship. Recently, the new SMC has come. It has demanded that it will construct a road through the courtyard of the petitioner, Lordship. This is refused. Thereafter, the school management committee filed a complaint before the deputy commissioner, district commissioner. We also filed an objection with forwarding copy to the DO, BO, circle officer, and SMC, Lordship. All of a sudden, the circle officer went to the house of the petitioner on 12/3, Lordship, and demarcated a 12-feet wide road through the courtyard of the petitioner. Lordship, may kindly see page 33. I have given a photograph, Lordship. Through the courtyard, and directed that the petitioner should remove his house within 16/3, 2 day, Lordship. Thereafter, on 13, we filed an application before the respondent number 4, that is circle officer. And after filing the application yesterday on Sunday, the circle officer went to the place of occurrence with full force and demolished the house of the petitioner. Lordship, may I kindly see the photographs I have annexed from page 36. And they announced that within 1 or 2 days, the road will be constructed through the courtyard of the house of the petitioner, Lordship.
Okay. Yes, any instructions?
This page 22.
22. Yes.
The allotment order law.
Yes.
4. This land cannot be occupied by others by inheritance without the permission of the district commissioner or subdivisional officers. And he is in his synopsis, Lordship, which is stated that after the death of his father, the petitioner and his family members have started to live on the said land, but what provision, Lordship? Only this thing, otherwise I have to obtain the instructions.
Other Lordship, DC has gone to the place of occurrence without issuing any notice, without any information, and without giving a chance of hearing, Lordship, and demolished my houses. Now they have proposed to construct the road through the courtyard of the petitioner, Lordship.
Mr. Hussain, demolition has already been done. What?
Demolition of the house is done, but partially. But if the road is constructed, then everything will go, Lordship. And I have stated in my petition also, in my objection to the Deputy District Commissioner also, that I will allow on humanitarian ground, I will allow through the
Okay, you get the instructions.
within the boundary of my.
Well, it's moved unlisted. Well, today is Tuesday.
Tuesday.
Today is Monday. When was it demolished?
Yesterday, Lordship.
Yesterday demolished all.
Sunday, Adhikatari. Well, you said you were given time till 16th.
Yes, Lordship, I have stated I was given time to 16, but yesterday they went to the place of occurrence and demolished the house, Lordship.
Can you have some instructions day after tomorrow?
Lordship, I have tried.
Okay, maintain status quo as on today. Okay. You are M. Hussain.
Lord M.I. Hussain.
M.I. Hussain, learned counsel for the petitioner who has moved this petition out of turn on the strength of a mentioned memo. Full stop. It is contended that the house of the petitioner has been forcefully demolished without any notice, and a road would be constructed through the courtyard. Full stop. It is submitted that the land was allotted in the year 1977 in the name of the father of the petitioners, whereafter the petitioner attorney has been residing over there. Full stop. The petitioner had also allowed ingress and egress of the students of a school which had shifted to the stated on the backside of the plot of the petitioner. And based upon certain complaints, the demolition has been done. What's the para? Sri Roy, the London State Council, has, however, submitted that the allotment order itself contains a clause that the land cannot be occupied by others by inheritance without the permission. Full stop. Para. Be that as it may, let instructions be obtained by Sri Roy, the London State Council. Let this matter be listed for motion on Wednesday. Day after tomorrow.
Lordship, then Thursday, Lordship.
Thursday. To balance the equities, it is directed that status quo as on today be maintained.
No, sir.
You inform the status quo.
Lordship.
You give extra copy. Today itself.
Today itself.
We'll try to have this order uploaded. Mother to? Yes, Mr.
May I please your lordship, my lord? What happened, my lord, in the instant case, my lord? And news item has been published first on 8, my lord, 9, my lord. That a case has been registered against the petitioners, my lord.
9/3/26.
Yes, my lord.
News are published
Yes,
where?
my lord, page 21.
News published where?
Purbanchal Pohori, my lord. And that the fact of the case is that I have taken, my lord, onion from Nasik. And I have paid 90,000 to a person, my lord. And 30,000 I am not paid because the onion has been perished, my lord. That is why the dispute is going on between me and that Nasik person. But what happened, my lord, in the instant case, the one of the person, Hardeep Singh, he is the, my lord, so-called, he is the president, or he has introduced himself as a president of, my lord, Truck Owners Association, has, my lord, threatened the petitioner with abusive litigation. I also reiterate it, my lord. And, my lord, a police case has been registered. Police is searching the petitioner in connection with this case, my lord. But, my lord, when the counsel of the petitioner has visited, my lord, office of PI office, case, you could not found the case number case, And we also inquired in the, my lord, Bosista police station, they have refused to give either GD&T or FIR, my lord. My fundamental right to, my lord, file a bail application, my lord. They cannot do like that, my lord. They have go to on the procedure of the law, my lord. That
Yes,
is-
Mr. Roy.
And my lord, once,
To obtain instructions
and my lord, there is,
actually happen, lordship. To obtain the instruction.
Where have you stated, Mr. Chaudhary?
yes, my lord. Your lordship kindly come to the, my lord, para 4. There is petitioner back to state that on 8/3/2026, one Harpreet Singh, who introduced himself as a national president.
You are a resident of Patna.
I am now residing in Gauhati, my lord. And do the business. I have also trade license, my lord. Or permanent resident is from Patna, my lord. I am in Gauhati for long time, my lord. I have given all the, my lord, address, my lord. National President of Northeast Transport Association has threatened the petitioner that he will kidnap the petitioner.
Paragraph?
Paragraph 4, page 7. Northeast President, the petitioner that he will kidnap the petitioner from his shop, Ganesh Katta Lokhra, by bringing goon from Beltola. Further, the said husband threatened the petitioner, claiming that he has a high-handedness in the Bosista police station and he can put the petitioner behind the bar in conniving with the official of Bosista police station. As due to his business transaction, he has a good relation with the official of Bosista police station. The petitioner further stated from the news item published in one esteemed newspaper of Hindi language, namely
You get the
Purba-
instructions.
Lordship.
Thursday we'll take this up.
But till
Heard
then,
Sri
worship
NNB Chaudhary, learned counsel for the petitioner, which has been, petitioner in this petition, which has been moved out of turn on the strength of a mentioned memo. Para, it is contended that due to some business dispute, the petitioner has learnt that an ejahar has been lodged against him, full stop. However, when the counsel of the petitioner had visited the concerned police station, concerned Basista PS on 12/3/2026, no information was revealed, was given, including the number of the GD entry. Did you go to the PI office?
yes, well, I have
Where have you stated?
I've stated my para 4.
Where is your stated about PI office?
But when the petitioner visited inspector office, prosecution inspector,
Well,
it-
okay,
top
okay.
line.
It is also. No, para?
Page 8, my lord. Top of that.
No, that
Visited
was
the-
been sent to, but where is that you have asked for the copy from the PI
Yes,
court?
my lord.
PI office.
May I read, my lord, para 7 last. The petitioner had stated, although as per said newspaper report is going on, but when the petitioner visited the prosecution inspector office on 10th,
Paragraph?
para 4 last line, my lord.
Para 4 last line.
Yes, my lord. The petitioner further stated, have you also got it?
Yes, yes.
Whereas, although as per newspaper, the petition investigation going on, but when the petitioner visited the prosecution inspector office on 10/3/2020, 11/3/2020, 12/3/2020, till that no copy of the said person has been sent to the Ileka Magistrate or prosecution inspector office Kamrup, which is CRS Bharatiya Nagorik Sanchar Sandhita. That is one. Thereafter, the petition visit the Bosista police station 12/10/3.
Okay, then, okay, Eviction. Yes, how have you verified?
Hello?
How have you verified this important statement? How have you verified in the affidavit?
Yes, my lord. Lordship,
This become matters of records. You go to office and you not find the.
No, my lord. Sorry to record for sorry, right? Sorry.
So how do you file petition and maintain like this?
Sorry, my lord.
And you are expecting this court to pass an order on your favor?
Sorry, I'm extremely sorry. It is
These are absolutely your personal knowledge.
Yes, it is a personal knowledge. Sorry, my lord. Extremely sorry, my lord.
If you do not maintain this, we are only dependent on your affidavit.
Sorry,
We are not a court on facts that will have Examination and cross-examination.
Yes, my lord, sorry, I'm extremely sorry.
Equal. Granted.
Annex are
Okay.
clear record হবে।
It is also stated that the copy of the Ejahar was not sent to the Elaka magistrate or prosecution inspector's office. Full stop. Para. Let instructions be obtained by Sri S. Roy, the Learned State Council. Let this matter be listed for motion on Thursday. Please give the date. 19/3/2026. Para. To Sri Chaudhary, the Learned Council, for the petitioner prays for some interim protection. Para. Considering the facts and circumstances, and by balancing the equities, whom it is provided that till the till the date fixed, that is Thursday date, no coercive action be taken against the petitioner, including the aspect of arresting him by the concerned police. Full stop. On the next date, comma, the Learned State Council would obtain the necessary instructions, including the aspect of registration of any Ejahar in with regard to the allegations. Okay.
I am extremely sorry, my lord. This should not happen on my.
Okay, rest dates will be given. Timing good was it? Huh? Oh, what was this, Mr.
Regarding allotment of land to the college, my lord.
Okay. I heard
Second time
Sri
it has been-
H.R. Ahmed, Learned Counsel for the petitioner. Full stop. In this case, notice was issued on 9/2/2026. Full stop. Sri J. Handik, Learned State Council, prays for and is granted 3 weeks for the time to obtain the instructions. We give a date, Mr. Ahmed. List on. Today is 16th. 1, 2, 3. We'll have it immediately after the bifurcation. Then 4 weeks, yeah. On 22nd of April. Okay.
My lord.
Item number 61, increment will be expected on today, my lord. That
Item number
61.
61, interim order passed. Any matters where interim order is limited till today?
61, huh?
Any matters? Oh, okay. Rest, if those are urgent, please request the court master, he'll give date. Otherwise, dates will come.